Hey chat, happy St. Patrick's Day. Happy day 2 of the Afroman trial. We left off yesterday in the middle of direct examination of Mona Lickum Down Low Lisa. Is that her full name? You know how I am with names. And that will continue today. We'll obviously get to cross after direct is over, which I'm sure will be a time. The court feed has not, I don't see them starting yet. And when they do, we'll get into whatever's going on with day 2. But in the meantime, there were a bunch of new filings that came through. I mean, they're posted for yesterday. I didn't really see them right after court ended. You can see the media requests were finally granted for people that had filed several days ago. And first one up on the list, we're just going to work from the bottom down, is defendant Joseph Edgar Foreman, that's Afroman. Motion in limine to exclude the testimony and report of Detective Michael Robinson. So we heard that name mentioned a little bit yesterday, and I was curious. So let's start with this one. And I'll have to keep refreshing. I don't have anything. Every few minutes I'll just refresh and see if we've got a live court. So let's see. Comes now the defendant, Joseph Foreman, by and through his counsel, requests the exclusion and prohibition of testimony by Detective Michael Robinson and admission of his report. The defendant was only put on notice of this witness and his report on March 2nd, 2026, and was provided with a copy of the report on March 10th, 2026, after a specific request to the plaintiff for said report. The entry of the witness and his report have prejudiced the defendant, and he was denied valuable time to depose the witness about his report and the procedure he followed. And remember, since this is a civil case, I don't know how Ohio is generally speaking, but with a civil case, part of discovery, you can request to depose witnesses that you expect to be called to see, what information might be relevant that you might need to know to proceed with the litigation. The exclusion of the witness and report from being presented at the trial, or a short continuance of the trial, is proper to cure this discovery violation and allow the defendant time to fully prepare a defense to the new witness and his report. So here's a memorandum in support. And again, Afroman's attorney is David Osborne. In 2023, we know the background, but let's do it again for anyone that's just, I didn't know this trial was happening. In 2023, the plaintiffs in this case filed a lawsuit against the rapper, Joseph Foreman, aka Afroman. This case has progressed, and a telephone status hearing was held on February 23rd, 2026. On March 2nd, 2026, plaintiffs served the defendant with proposed exhibits to be used at trial. Contained in that email was a mention that they also, quote, intend to introduce documents related to the investigation of the alleged $400 discrepancy. Oh, such a wonderful use of time. See Exhibit A, email from plaintiff attorney, do we have that? Natalie Gratzer to defendant's attorney David Osborne Jr. Let me see. All right, so March 10th we have DJ. Here is the report and this spreadsheet referred to as an attachment from Bob. So this is opposing counsel. This is plaintiff's counsel. So I guess Osborne goes by DJ and Robert Klingler goes by Bob. So there you go. We have shorter names for the chat to use. We've got, let's see. This came first. Okay, so David's came first. Bob, I see you added him in the report. Have you ever disclosed the report to me? I have not seen a copy of the report. Thanks. So there you go. This is your disclosure at 5:20 p.m. on March 10th. After a very specific request. Let's see. Before that, it's DJ attached. Please find plaintiff's amended list of witnesses and exhibits. We added Detective Michael Robinson from the Clermont County Sheriff's Office, his investigative report about the cash discrepancy, and the Brian Newland, who was the first witness we saw yesterday, showing the cash count. Please let us know if you have any questions. And then before that, so wait, this is the most recent one then. This is after the other four. It says, counsel, please see the attached plaintiff's witness list. Or no, I lied. This is March 2nd. So all those are March 10th. This was March 2nd. And this is from Natalie Gratzer from Klingler Law Firm. Counsel, please see the attached plaintiff's witness list. Plaintiff's exhibits can be accessed at the link below. So this is them sending their discovery folder. Plaintiffs reserve their right to supplement these exhibits. We also intend to introduce documents related to the investigation into the alleged $400 $400 discrepancy. Let me know if there's any issues with accessing the files. We're assuming you will stipulate that the social media posts and songs at issue in this case were posted on accounts owned or controlled by Mr. Foreman, and that he posted them, or authorized their posting, ? Please confirm or let us know if you will not stipulate. Thanks, Natalie. So there we go. That's the email thread being referenced up here. Let me refresh this court feed quick while we're scrolling. Nope, don't see it. So, all right. So Exhibit A, we just read that. The provided exhibits do not contain a copy of the report nor name Detective Michael Robinson as a witness. This was not learned until March 10th, 2026, when plaintiff's attorney is Robert Klingler. I guess am I adding the L on accident? Or are we just, hold on, let's go look at his email signature. Are we just auto-correcting him to being a Klinger? Yeah, there's 2 L's in his name, according to himself. But this motion's spelling it the way I keep spelling it, just calling him a Klinger. He emailed defense attorneys David Osborne Jr., the amended witness, and exhibit list. And then Exhibit B, which we also read, that full exchange. Strangely, in his email, Attorney Klingler notes that he has added the detective and that they will play some of the body camera footage of plaintiff Brian Newland counting money during the search of Mr. Foreman's residence. No copy of the report was provided to Attorney Osborne. Attorney Klingler did not reference the report in his email. It was only upon review of the attached exhibit and witness list and a specific email request that Attorney Osborne was provided with a copy of the investigative report of detective. So that's that whole email thread. Yeah, a lot of this is over $400, and I'm going to call it an excuse. To me, it completely sounds like an excuse. And again, it's either missing money or dumb incompetence, and that's a problem for chain of custody, for evidence handling in general. The explanation we got from the first witness yesterday, Brian Newland, he didn't seal the envelope that they put the cash in when they seized cash from the home. And then he says he miscounted and wrote the wrong number on the envelope. And it's not like he wrote the wrong number and it was like, you know, he switched the order of numbers around. It was evenly $400 different. And the amount in the bag that was returned was less than what was written. It wasn't a mistake in the opposite direction. So a lot of this is about $400. And I think the explanation, and I'm not saying Brian Newland himself is the one that took it, but why didn't you seal the envelope? And why are you just leaving an open envelope with cash money sitting all willy-nilly somewhere? So, all right, every time I rant, I'll refresh and see if there's court feeds. All right, none from WCPO9. All right, so we've got, let's see, discovery is a messy process. Well, so is apparently the evidence collection, by which a significant amount of evidence is requested and sorted. Each side looks at the evidence differently, and builds their case and defense based on their views of the evidence. However, mistakes occur. Sometimes these mistakes have effects on the opposing party. The plaintiff, why are we doing like a 101 here? I feel like that's intentional. I feel like, you know, typically these attorneys wouldn't put such a level 100 law explanation of the process in here. But maybe the baby talk is for a reason. So the plaintiff has committed a discovery violation by failing to put the defense on notice of a new potential witness and to provide his report in a timely manner that would not prejudice the defense. Ohio Supreme Court held that a trial court must inquire into the circumstances surrounding a discovery rule violation, and when deciding whether to impose a sanction, must impose the least severe sanction that is consistent with the purpose of the rules of discovery, applies equally to defendant discovery violations committed by the state and to discovery violations committed by a criminal defendant. We have a footnote that's State v. Woods. All right, what about civil cases? The Supreme Court went further to state that they believe that the equal and reciprocal treatment of parties is important when looking at discovery violations. Same case. Also, that considering sanctions, the court shall investigate and impose the least severe sanction that will further purposes of the discovery rules is a critical consideration that must be taken into account in any ... case before a severe sanction is imposed for the discovery violation. The Supreme Court emphasized the 3 factors that should govern a trial court's exercise of discretion in imposing a sanction for a discovery violation. These are whether the failure to disclose was a willful violation, whether foreknowledge of the undisclosed material would have benefited the accused in the preparation of a defense, and whether the accused was prejudiced. I think this all were from State v. Woods. Yep. However, even with the violation, the court must look at the least restrictive alternative. In the case at hand, the plaintiffs have totally failed to even put the defense on notice that they plan to call Detective Robinson as a witness and present his report until it was too late for the defense to depose and prepare a defense to the witness. The first prong of the Supreme Court, and it's kind of critical because they knew they were going to call Brian Newland first. So, I don't know if you guys are seeing it the way I am. My personal opinion on the strategy of the plaintiff is put Brian Newland, put Lisa on the stand first, because they have the most pointed statements that were said about them, right? It's not just oh, you're mad because somebody said you're looking at lemon pound cake. It's you're being called a statutory pedophile. You're being called claims that you possibly had a sex change. Those are things that I feel like the plaintiff's attorney might feel like are the strongest thing to intro right to the jury. Right? So if you know you're going to call Brian Newland first, and Detective Robinson's going to be in here to say he independently from another sheriff's office came in and investigated what was going on with Afroman's claim of the stolen cash and found no wrongdoing. So essentially he's there to bolster Brian Newland's claims and testimony that I didn't do anything wrong. I didn't take any money. No money was taken at all. It wasn't just me. So, pretty important witness to disclose. So, the first prong of the Supreme Court analysis is to determine if a discovery violation took place. The plaintiff was served with interrogatories over a year ago, and because remember, this has been going on since 2023. And civil cases move slow, but still. And when those were finally supplied to the defendant, no Detective Robinson was listed or disclosed. The first that the defense knew that Detective Robinson would be a possible witness was March 2nd, 2026, when the plaintiffs indicated they planned to introduce evidence of the missing money investigation. Even at that time, the defense was not made aware of the names of witnesses. The name was only disclosed on March 10th, 2026, when the plaintiff's amended witness list was provided. The violation does not stop there. Each party is under a continuing duty to turn over evidence to the opposing party. Each party has already made the demand, and it is not contested. Yet, Attorney Klingler, rather than sending the report, which had never been provided or disclosed before, required Attorney Osborne to request it in a follow-up email. Such actions show that Attorney Klingler did not plan to supplement the plaintiff's discovery as required. When viewing what occurred, the only conclusion that can be reached is that a discovery violation occurred. Once the first prong of the Supreme Court analysis is completed, you must move to the second prong. Would the foreknowledge of the evidence and witness have benefited the accused in preparation of a defense? The answer is yes. It would have benefited in the preparation of a defense to the witness and report. The record clearly shows that every witness disclosed by the plaintiffs has been deposed and asked extremely in-depth questions. And we're seeing some of that deposition footage interwoven in some of these videos that Afroman's releasing. When the trial concludes, I want to put in a request for at least some of those depositions. Maybe not all of them, but that could be a fun time. So, let's see. Questions about methodology, interviews, etc. would have been asked to build a defense to the testimony of the detective and his investigative report. Or even things like, are you friends with anybody from the sheriff's office? How independent is your investigation into this $400? So, thus, the second prong of the Supreme Court test is met, as the foreknowledge would have helped the defendant prepare a defense. The third and final prong of the Supreme Court's test is if the defendant was prejudiced by the violation. The defendant has been prejudiced as without a deposition. And I love seeing the typos, because it's like a human wrote this. Or humanoid. So the defendant has been prejudiced as without a deposition of the detective. He will not know what the detective will testify to with specificity. Further, a witness being on the stand is the wrong place to conduct a deposition to ask open-ended questions. This is supposed to take place prior to trial, so that valuable court time is not wasted. Further, asking open-ended questions on the stand of a new witness could prejudice the defendant by introducing evidence that would otherwise have not been admitted. Thus, the defendant was prejudiced by the addition of the new witness in his report. And I always wonder, like, if the witness, like, blurts something out that ends up opening the door, but this was a discovery violation, now there's, like, an additional pickle. Like, and I don't get the vibe from this judge that the judge would err on the side of caution in trying to keep the record clean if this spiraled out of control. Oh, thank you. Me up here pointing out all the typos, and here I am with one in my banner. While we wait. There we go. Thank you, thank you. So that is now correct. So big thank you for that, Jenny. And hold on, let's see. So court hasn't started. And Ohio isn't one of those states that has 2 time zones, is it? Because in my mind, Ohio is the same time as I am right now, 9:18 a.m. in the morning. But I'm wondering if they're arguing some motions this morning, and the feed isn't just going to give us a feed of out-of-jury presence stuff, which I'd like to see, so it would be cool if we had footage of that, but I guess we won't. So thus, the defendant was prejudiced. And then the final question to answer is, what is the least restrictive means to correct the violation? The court could grant a continuance of a short time to allow the detective to be deposed. This would allow the defendant to prepare a defense to the detective's testimony and report. Alternatively, the court could order the exclusion of the detective's testimony and report. The least restrictive option is within the court's discretion. So wherefore, that's what they request. So that was one thing we had. Let's see. Okay, yeah, you guys are saying 1 time zone. Yeah, not one of those weird states with split time zones. Very confusing. Like Tennessee is one of those, right? So, is it? Oh, you know what? I forgot. When I update a banner, I have to, click it twice for it to actually refresh. I did correct the spelling back here, but I've got to turn it on and then turn it off and then put it back up for it to correct itself. So there we go. We've got, let's see, what else is on here? Also, shout out, I see I'm not a lawyer.but.com. Media permission request granted. So shout out while the name is here. So there we go. All right, next one is defendant Joseph. Let's see. So defendant Joseph Edgar Foreman, memorandum in opposition to plaintiff's motion in limine to exclude irrelevant evidence. So over the weekend, we'd looked at a motion in limine that the plaintiffs filed. They wanted to exclude the "Will you help me pay for my door" video, the lemon pound cake video, and they requested, if you don't want to exclude the whole thing, can you please restrict what's able to come in to just the part where you see Brian Newland counting money. Those are some of the requests. They also asked to exclude some of the witnesses that were on the witness list that seemed to be former or current partners of some of the plaintiffs. I believe one of the most relevant ones, Shawn Grooms' ex-wife or ex-fiance, she's the source of some of the allegations, some of the statements that Joseph Foreman had made about Shawn Grooms, about inappropriate conduct. So I think she's relevant. Kind of hard for him to raise a defense on why he would make a claim if he can't bring in why he's making a claim. And then they also asked to exclude a Trinity White Knights flyer. So, all right, a no court feed. All right, so comes now the defendant, Joseph Foreman. Let's just get to the memorandum. No, let's not. This is spicy. He says, by and through his counsel, request motion in limine to exclude irrelevant evidence be struck and denied. The plaintiffs seem to be confused in relation to evidence. Just because evidence may be relative to a dismissed counterclaim does not render it worthless. Rather, evidence can be relevant and admissible for several purposes. Just because the plaintiffs cannot understand um just because the plaintiffs cannot understand why evidence would be listed, or they know that the evidence will paint them in a negative light, does not mean it's irrelevant. A memorandum in support is attached here too. So here we go. In 2023, plaintiffs in this case filed a lawsuit against Afroman. The case has progressed and is set to go to trial. Yeah, definitely trolling. That's the vibe I got from the previous motion, but it was very subtle. This one was just like out the gate with it. Yeah, and trolling the judge too. So, and I think the Afroman song that you'd linked earlier, the one that's to the tune of Glory, Glory, Hallelujah, the Afroman's coming to you. I think Afroman's grouping the judge in with his criticism. This judge, not just the search warrant signature judge, with his ongoing criticism of everything that's happening with these plaintiffs. So, just a time. And let me keep this banner up here. I don't want anyone to come in and be like, why aren't we watching court? It's not up yet. All right, so we've got the case is progressed and is set to go to trial on March 16th, yesterday. On March 11th, 2026, there's a footnote. It should be noted that the proof of service lists the incorrect date of service as March 9th. A corrective filing will be filed with the court. Plaintiffs served the defendant with... So the plaintiff's proof of service says March 9th, but it's actually was served on March 11th. I mean, maybe that's like mincing hairs, but 2 days when you're a week away from trial is pretty significant. Plaintiffs served the defendant with a motion in limine to exclude irrelevant evidence. This is based on the filing of the proposed witness and exhibit list, and the judge was confused about that yesterday, of the defense filed prior to March 11th, 2026. Okay, another footnote. It should be noted that the defendant has filed an amended proposed exhibits and witness list. The new list does not contain the flyer at issue, rendering any issue with that possible exhibit moot. So they're not going to try to bring in the Trinity White Knights flyer. The plaintiff takes a strange position that they can see into the mind of other attorneys by representing to the court that a significant amount, if not all, of the evidence the defense will be using will be sensational exhibits that attack and belittle the plaintiff deputy sheriffs who executed a legal and valid search warrant on his property. I mean, you guys are the ones that just played the entire Lisa Lickham Low video yesterday. Footnote says plaintiff's motion in limine to exclude irrelevant evidence or citing to page 2. Why the plaintiffs believe this is not clearly articulated and appears to seek not an order but a deeper look into the defense that is planned to be presented. After all, Mr. Osborne is not the brightest attorney. Is he talking about himself? After all, Mr. Osborne is not the brightest attorney and maybe nothing more than a hillbilly hick. Yet it seems that the plaintiffs are finally understanding why Mr. Osborne was hired. What are we doing? Okay, the motions are just as good as the trial in this chat. Oh, man. This is so great. I love it. All right, this is why we read motions, you guys. So if you're new here and you take a look and you're like, oh, all her other stuff's reading motions, this is why. Mr. Osborne is a resident of Adams County and has known all the plaintiffs for a long time and knows all the good and bad in relation to them. Why is this important? The plaintiffs, if worried about what other purposes the proposed evidence would represent, should have completed a more in-depth discovery process. After all, Mr. Foreman was deposed longer than any other witness in this case. We have to request that. By not just one plaintiff's attorney, but two. Yet, now the plaintiffs seek to toss out all the evidence that the defense has disclosed or to force the defense to explain before presentation at trial why or what all their evidence will be presented for. The evidence that can be admitted at trial is governed by the Ohio Rules of Evidence. Under the Ohio Rules of Evidence, Rule 401, Ohio adopts like the federal code numbering too. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And a footnote here says, oh, they're just the cite. However, 401 must be read in conjunction with Rule 402. Rule 402 states that all relevant evidence is admissible, except as otherwise provided by the Constitution of the United States, by the Constitution of the State of Ohio, by statute enacted by the General Assembly, not in conflict with the rule of the Supreme Court of Ohio, by these rules, or by other rules prescribed by the Supreme Court of Ohio. Evidence which is not relevant is not admissible. Rule 401 and 402 work together to form the cornerstone of trial evidence. The limit on evidence is found in Rule 403. Rule 403A, which, gotta love Rule 403, states that the exclusion of evidence is mandatory when, to wit, quote, although relevant, evidence is not admissible if its probative value is substantially outweighed by the danger of unfair prejudice, of confusion of the issues, or of misleading the jury. Rule 403B states that the exclusion of evidence is discretionary when, to wit, although, this is like 101, although relevant, evidence may be excluded if its probative value is substantially outweighed by considerations of undue delay or needless presentation of cumulative evidence. Thus, the first question when determining if something is evidence. The second question is whether the evidence is relevant, and the final question, if needed, is an analysis under Rule 403. So in their motion in limine, the plaintiffs seek to have the songs Lemon Pound Cake and Will You Help Me Repair My Door excluded. The plaintiffs claims that these two songs are irrelevant, and if introduced, will create a substantial likelihood of confusing the jury. Yet how these songs are irrelevant and confuse the jury is not articulated, a fatal flaw in the argument of the plaintiffs, as they have the burden of proof as the party making the motion. The plaintiff cannot see how the defense will present their case and are using a vague motion in limine to attempt to get a view into the defense. This can be the only explanation for why the plaintiff does no analysis in their motion. They know it will be denied, but hope to get a leg up at trial. However, before the defense tips its hand on how the evidence listed will fit into their defense, the song Lemon Pound Cake must be addressed. The strangest part for the motion in limine of the plaintiffs is that they would seek to exclude the song Lemon Pound Cake. Yes, exactly. And that's why we did a whole stream where we're like, am I missing something? And everyone was like, no, this doesn't make sense. Like, this all started because of Lemon Pound Cake. Like, how is it irrelevant? So the plaintiff, Shawn Cooley, has claimed that he has been defamed, put in a false light, and had privacy given to his private life by being called Officer Pound Cake. Where did that name come from? It comes directly from the song Lemon Pound Cake. Oh, just toying with him. So it is unfathomable that the source of the name that plaintiff Shawn Cooley is claiming injury for should be eliminated. Just because evidence is unfavorable to one party does not make it excludable. Why does the plaintiff want this song excluded? Because if you view it in conjunction with the testimony of plaintiff Shawn Cooley, his claims will fail. Because he looks at the pound cake twice. Further, the song clearly destroys plaintiff Shawn Cooley assertions, as it shows artistic expression protected by the First Amendment of the United States, the Constitution of the State of Ohio, and by Ohio Revised Code Section 2747. The music video is relevant here because it shows context and provides context for the defendant's defense of freedom of speech. So similarly, let me just check this court feed, just so you guys know. Let's see. All right, they're going to be live. So let's stop here, and we'll come back to this motion with the "Will you help my repair my door" stuff, and let's do the trial.
Plaintiff's Exhibit A. Okay.
Oh.
So. Okay.
No, what? So we missed Cross of Lisa? I'm not missing one, right? This is from yesterday. No. All right, chat. Well, we've got what we've got.
It had to do with the.
It just starts in the middle of this, guys.
Kind of goes without saying, you're not a judge. Okay. So there is more reasons then than Mr. Foreman.
This sucks.
That caused you to leave the sheriff's department.
It had to do with the handling of this case.
Can you tell me what fact about you that receding hairline or dipshit refers to, please?
I'm sorry?
What private fact of yours does that refer to?
Oh, here's
It
better
was-
volume.
It had to do with the handling of this case.
Can you tell me what fact about you that receding hairline or dipshit refers to, please?
I'm sorry?
What private fact of yours does that refer to?
I mean, there's a picture of me, and let's see here. Talking about, see, I wouldn't trust him with methamphetamine crack ass alone in my house. I
So,
find that pretty insulting.
so that statement is what
That's-
you're suing on?
Well, no. I told you this is one of many.
Well, and that's why we're trying to
You
find.
keep trying to make it singular. I'm telling you, it's not singular, it's plural.
Okay, and so one of them is dipshit, one is receding hairline.
Yep.
And the other is methheads.
Yes.
Is there any more?
Well, when he's sitting there making accusations against the organization that I, at that time, was working for, destroying community trust, all based off of a lie, that's what ultimately stopped.
And that's community trust in the Adams County Sheriff's Department, correct?
Yes.
Let's go back to what was Plaintiffs Exhibit 5.
Okay.
Oh,
I unfortunately don't do technology very well. But this was Plaintiffs Exhibit 5. You said this was referring to you. Where's your picture in this?
I said, you asked me earlier.
Where's your picture?
No, you asked me earlier.
Your Honor, I'd ask the witness to answer the question.
Okay,
You can clarify that there's read.
okay, okay.
Is your picture in this post?
No,
Is that a picture of your father?
yes,
So this actually pertains more to your father than you.
correct.
I'd like to look at what was Plaintiff's Exhibit A.
Can you turn a little bit,
Well, here, help me then.
just turn it slightly, there, right, yep, perfect.
Okay.
Okay.
So there's no Plaintiff's Exhibit A.
Oh, sorry, Plaintiff's Exhibit 1.
Thank you.
So this would have been Plaintiff's Exhibit 1. It says, "In court early." Were you at that hearing?
No,
So this is a post about a legitimate hearing that we have in this case.
right.
But you weren't present there.
No, sir.
Do you know if your attorney was present?
I don't know.
This kind of goes without saying, you're not a judge.
Nope.
What's
You're
the
not.
Exhibit number?
Oh, are you not?
Thank you.
This would be Plaintiff's Exhibit number 6, the one about Roy Gabbard. You're not a judge?
Nope.
You're not Roy Gabbard?
Nope.
And other than this referring to the Adams County Sheriff's Department, somewhere towards the end, that is the only thing in it that you believe is the plaintiff?
I'm sorry, it kicked on right when you were talking, I couldn't hear you, the AC
Let's
kicked
strike the
on.
question.
Okay, I'm sorry. Poor timing.
This would be Plaintiff's Exhibit number 8. You said you saw this sometime after?
Yeah, it wasn't the day of, it was sometime after, I don't recall.
How long after?
Within a week, I'd say, probably.
But you're not identified in here?
No,
And it just talks about the department in general.
correct,
It just talks about a guy that hit Mr. Foreman's mailbox.
correct.
And you didn't hit Mr. Foreman's mailbox?
No,
Okay. Were you ever disciplined because of what happened in the raid?
no,
Were you ever disciplined for anything Mr. Foreman said?
no.
Other than your voluntary resignation, have you lost any other income?
I've been employed in a year, I've been living off savings. You know, I can't keep gainful employment because I'm going to VA appointments 5 days a week sometimes.
Well, you said that you went to surgery. When did you go into surgery?
I don't remember, that's been so long ago. It was,
It was a nice time at home. You didn't have
oh my
any
gosh,
duties.
yes.
Was it a long time ago?
I don't recall. I'd say it's been over a year, but the dates, I'm sorry, I can't recall it.
So, is the allegations of you being a thief come out of the handling of the money during the search of Mr. Foreman's residence?
Yes.
During depositions, I asked you some questions about how money should be counted and cataloged as evidence. Can you explain the process to me of how you count and catalog money as evidence?
Yeah, I mean, you, as far as like what the policy is, or because I don't that policy has changed since then, and we had, but usually what you do is we have a special type of evidence bag. That evidence bag, it'll have denominations of bills.
Okay.
On that, you count it and you mark it. You know, I got 3 20s, I have 1 10. You know, you put that money in the bag and seal it up. Does that answer your question?
So you have these evidence bags, you would count out the money, you'd have it recounted, you would then like put a stack of 20s, 10s, 5s, and then down the denomination?
Yeah, it's not counted by the total on the bag, it's counted by each individual bill and the amount of each bill. So you have 3 20s.
Mm-hmm.
You don't put the total amount of currency, you put the number of bills.
So you
On
could tell if a
that
bill's
type
checked.
of evidence bag, yes, sir.
Okay. So let me rephrase my question as we were
Okay.
talking at the same time. So if I look at the evidence bag, I can know exactly how many 5s are in it, 10s, 20s, 100s?
Correct.
Okay. And the evidence is sealed when it leaves the scene?
Most of the time, yes, but as long as it stays in your care and custody, as long as it's not something, if this was something that had a fingerprint, of course, you'd have to protect that fingerprint until you can get it to a lab. I'm not going to say that
You don't need to
every
protect
time
money?
you leave somewhere, something is sealed, because sometimes, I mean, that's an unrealistic expectation.
Why?
You know, if I got a gun, but I don't have a gun box to put it in, well, that's going in the trunk of my car until I get a gun box to put it in.
That's not cash
I mean,
money.
That's the reality of law enforcement.
But if that gun changed hands by 3 or 4 people, they would all sign the box when they got it to show the chain of
Correct.
evidence?
Yes, sir. Yes, sir.
So anybody in possession, that must be in the chain of evidence?
Correct.
And that's put on the bag? Or the box in that case?
Well, there's a little thing right on the front. It'll have an evidence chain right below the denominations. It has an evidence chain.
So if you collect a gun, you would sign first. If I hold it, I'd sign second, and so forth and so forth?
Correct.
Now, what happens if you don't have these special evidence bags and you just have a clear bag?
Can you tell me where you're going with this? Why it matters?
This matters,
Oh
Your
my
Honor,
God.
because there is a question about the policies and procedures, and as I said, Mr. Robinson is going to testify, if he's admitted to testify, about an investigation he did. His investigation is very limited, at least from his report would indicate he only watched video footage, never interviewed anybody. So, one of the things I have to counteract that is the fact that the evidence was not handled correctly. And that is what I'm building here. Mr. Cooley is testifying about the exact way in which you would put
What
that
does
in.
that have to do with any issue in this case?
Your Honor, the issue of money is, and missing money is at the very issue of, they say they're being called thieves. They're trying to prove it's not a fact. I'm trying to prove that from the evidence and how things were done, you cannot even make that conclusion.
You just have to call Mr. Robinson.
Yes, we do, Judge. Please ask him to be here one more.
Because in one respect, it's your time to spend. I look at this as marginally relevant. You can spend the time.
Thank you.
Have at it.
So if you had a plain evidence bag that did not have the place for 5s and 10s, would you
It's-
handwrite in that information with a permanent marker?
Yes.
So even if the bag was plain, you could write 10 5s, 2 20s, and such?
You can.
But that's the way it should be done, though, correct?
Well, I'm not going to say that's the way that happens every time. I mean, it's as long as you can protect that evidence to display in court. That's the purpose. You know, I mean, there's a little bit of flexibility in evidence handling based off the situation, but in general, if cash is seized, then yes, you know, you can put the amount. The amount is always going to be on the outside of the bag. Anybody that took exclusive possession of that, yes, they're going to sign that.
Okay, and so, and the money's always counted twice, correct?
Correct.
At least twice, correct?
Correct.
Even the officer himself probably counted it twice, correct?
10 times, honestly. Personal choice there, it is.
First, you would count it though twice, correct?
Yeah, but
Did you ever have possession of the money during the search of Mr. Foreman's
To
home?
be honest with you, I don't recall. I don't believe so, but I don't recall.
Forgive me.
Big thank you to Amber. I'm hearing a lot about people who watched like the Pike County Massacre trial, and this judge was part of that trial, which I didn't see. But some of the way he's maneuvering just through day 2 so far, we watched like a half day yesterday and a little bit of today, and it's like, this judge seems to be a little sus to me.
I have no further questions for Mr. Cooley or Justin Cooley at this time.
Oh, this is Justin. I have the wrong man. Oh, Shawn is the pound cake guy.
Please call Mike Estep.
All right, Mike Estep is next.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? As this, you shall answer unto God.
I do.
Thank you.
Would you introduce yourself to the jury, please?
Michael Estep,
And Mr. Estep, how are you currently employed?
Adams County Sheriff's Office,
How long have you been with the Adams County Sheriff's Office?
over 24 years.
What's your current position with that office?
Road Patrol Supervisor.
How did you get started in law enforcement?
Through the fire service. Actually, some friends in law enforcement were in the fire service and kind of hung out with them, and that's how I began to take an interest in law enforcement.
You live here in Adams County?
I do,
How long have you been in Adams County?
all my life.
Do you have family here?
I do,
You married?
yes,
Children?
yes,
The children go to school here, did they?
yes,
You were part of the team that executed the search warrant on Mr. Foreman's home, is that right?
yes.
Did you steal any money from Mr. Foreman's home?
No,
Looked right at him, at the jury.
You've been here the whole trial so far, the last day and a half, right?
yes,
You've seen all the exhibits?
yes,
You saw the exhibits that were just shown to Justin Cooley?
yes,
Did the posts that we've been talking about here in this trial have any effect on you?
yes.
Explain what you mean, please.
People that we deal with in providing services into the community has called us out, called me a thief. We assisted with a search warrant service here with another agency, and the people who was inside the residence looked at us and says, why are they allowed to do what they're doing? And then they look at us and say, well, you done it to Afroman, they can get by with it, they can do it to us.
Did you ever receive any calls having to do with this case?
Not directly.
Are you aware of calls that were received by dispatch?
Lots of them.
Tell us about that.
My daughter actually works in the dispatch center, along with all the dispatchers that I'm very familiar with, that I work with as co-workers on a day-to-day basis, called and anything from why did you do this to why did you tear down the door, why don't you pay the guy back, you guys are thieves, and on and on and on.
Your Honor, I'm going to object. It's hearsay. He was not there, he did not have the phone calls, he's hearing them actually third hand, the way he's describing it. He's hearing them from the idea of, from the dispatchers telling him what another person said, so hearsay upon hearsay upon hearsay.
What's the purpose?
The purpose, Judge, is to, my next question was going to be, what effect hearing about these calls to dispatch had on Mr. Estep?
Wait. Just for the jury's benefit, if the content of the calls was an important issue, then we wouldn't let it come in. The speaker or the hearer would have to testify. But the nature of the call and how it affected him is probative, relevant in this case. So the general description of the calls in the context of how it affected him is the reason you're allowed to hear, not the accuracy of the call, but the effect on the person. Something else, Mr. Osborne?
No, thank you, Your Honor, just for the record.
No, you're good. Thank you.
Thank you. So Mr. Estep, tell us what effect it had on you hearing about these calls that dispatch was receiving about this warrant execution. And
It
you,
developed a serious concern of safety to not only to me, but the people working with me on those shifts. The days that I was working, basically overwhelming of calls that came through. And they were hardly able to keep up with what we have going on in the services that we're providing with nonsense phone calls.
are you aware of any effect that these that these posts had on the sheriff's website?
Your Honor, I'm going to object. That is beyond the scope and not even relevant to this. The Sheriff's Department is a government agency. You cannot defame a government agency.
Sustain.
Yeah.
For the record.
Mr. Estep, did you, through your attorney, ask Mr. Foreman to take these posts down?
I did.
Have they been taken down to your knowledge?
No.
Those are all my questions. Thank you.
Go ahead, Carl.
Mr. Estep, do you mind if I call you Mike?
That's fine.
Just call me a hillbilly hick or whatever I wrote in my motion.
You've been an officer for a very long time, over 21 years.
Actually, over 24 full-time years and over 38 and a half as a certified peace officer.
Dang, you should have had him count the money.
And during that time, you've never hid your identity as an officer?
No.
Everybody's seen you out in public?
Yes.
Seen you with your wife and kids?
Yes.
And your wife... Strike that question. And so you wear a uniform while you're on duty?
I do.
And you were a sheriff's deputy in 8/21 of 22?
I was.
Okay. And people have criticized your duties before, correct?
Yes.
And you've been called a lot of names by people in 24 years, correct?
Oh, yeah.
Things worse than a thief, correct?
Name-wise, but not not as detrimental how people look at you. I mean, you're saying, people calling you names directly, but not put out there to be detrimental in something that is criminally related.
So people have come up to you and asked you if you were a thief.
I've had phone calls and I've had it happen.
When was
Phone
the first
calls.
time that happened? To you personally during your career?
In my entire career?
Yes.
I never had anything until this came about.
You never had anybody
Not
ask you
told me.
about being a thief and when
No.
your wife was charged with theft?
No.
When your wife pled guilty to stealing from her employer?
Tell me why you would do that to the jury.
Your Honor, I
Why
would
you
ask
do
this.
that to the jury?
Your Honor, I'm asking a question that builds on his reputation. He says he has never been called a thief before, yet he keeps saying that everybody treats him differently. This goes to his reputation. He is used to this. Has happened before. To say that this is the only thing causing the problem has ever hurt his reputation, he's opening up the door so that I can ask the question about what's
Look at his
affecting his
face.
reputation.
Thank you. Mr. Klingler?
We're not going to, I assume, have a trial about every family member and what every family member of these plaintiffs might have done in their lives. This is a case about these deputies and about Mr. Estep. It's not
And his
about
reputation.
wife, it's not about his family. We're going to try a case here about what somebody else might or might have done, or whether they might or might have not been guilty. It's about what he experienced as a result of these.
And how it affected his reputation, which is exactly at issue. He is talking about his reputation and how it's been affected. He's opened it up. Your reputation is your entire life, everything you do in the community. Your family affects your reputation. You can't say that you have, if my brother gets in trouble and people ask me about that.
This case is about what he did to his reputation, not about what.
What was his
did-
reputation like before this started then?
You know.
So how about you play this out in front of the jury so they can understand how to separate the evidence? There's no claims here for your benefit, ladies and gentlemen, for family member injury. Right? But how family members' reaction to claims affect a person's relevant. So you get to hear that my daughter was upset when I was called a derogative term for the benefit, for the relevance of how it hits me. Right? Now, take that to this step. If we allow, and we will, testimony about the wife's prior experience, it only goes not to the character of that person, but how it affects the witness. So, like, we're not here to try to decide whether or not the spouse has a character flaw or not, but how the whole thief reference should play into his claim.
We got air quotes.
Right? Their law school example, arguing with each other, is what lawyers do, but you need to understand how to see it. So I'm going to allow this so you can see how it does or does not affect him alone. Just don't get caught up that your spouse's character is your character, because it's not. Enough said, overrule the objection, and then you can renew them as you feel appropriate. Go, re-ask the question.
He answered the question, Your Honor.
Then re-ask it because he shouldn't have.
Okay. So restating the question, Mr. Estep, your wife did steal from her employer, correct?
Yes,
And it was a felony sum of money, correct?
yes,
Which is over $1,000.
yes.
Did she think she would get away with it because her spouse was in law
And you were
enforcement?
part of the search of Mr. Foreman's residence, correct?
Yes.
Did you ever have any contact with the money?
I noticed money in a coat pocket and I pointed it out to Detective Newland.
And is that the money that Mr. Newland testified earlier that was upstairs?
That should have been some of it, yes. I didn't do the collection of it,
You just pointed it out in the pocket?
yes.
Another officer took it out of the pocket?
I assume.
Okay. Do you remember which officer you pointed it out to?
I told Detective Newland.
You realize that during that search, everything you said was captured on your body cam, correct?
Absolutely.
Did you ever make derogatory remarks during the search warrant about Mr. Foreman?
Not that I can recall.
But we're going to lay the foundation. Mr. Estep, on October 21st, 2022, did you have a body cam on during the search of Mr. Foreman's residence?
Yes,
Was that body cam active the entire time?
yes,
Does it have audio and video recording capabilities? If I show you a clip of that body cam, can you
Sure.
identify it?
sure.
For the benefit of the record, this would be marked Defense Exhibit B. And for the sake of the record, the file would be ACSO3_OK0019_21252.mp4. This is a clip of that file.
Is there a way to note what portion or time or clock, or when you plug it in, if there's a clock time,
It should have the date, time, and the timestamp it goes through on it.
The court of appeals should know that you didn't play the whole thing, you just played X amount of time.
Yes, Your
That's what I'm
Honor.
looking for.
As there's over 8 hours of body cam footage, we
Yeah,
have to.
we just have to make a note. Tell me where you're starting it, when you're starting the time clock. Is this?
Yes.
Okay. Okay.
Shout out to VLC Media
Your
Player.
Honor, this would be marked body cam in the upper left-hand
Oh.
corner, in the bottom left-hand corner. It has 8/21/2022, sorry, 8/21/2022, starting at 20:56:02.
That's where you're gonna start playing.
Actually, Your Honor, hold on a second here. It would be starting at 20:56:00.
Thank you.
Mr. Estep, I'm going to ask you a few questions before I play this. Can you see what's been marked Exhibit B?
Yes.
So, when your body cam is recording, does it record in color?
Yes.
Does it also record in black and white?
Yes.
Okay. Now, looking at this, does this appear, as you can recall it, to be the inside of Mr. Foreman's bedroom?
Yes.
And is the... I don't know why I did that. Did you happen to see the date in the bottom corner of it?
Yes.
Is that the correct date for when you searched?
Yes.
So this would be a copy, a segment of your body cam taken that day?
Yes.
I love technology.
Your Honor, maybe approach.
Oh,
What's it have to do with?
It has to do with what I think might be coming up. I wasn't aware that this was going to be shown, but I'm concerned about something.
Sure.
Panic.
Stand up, don't leave, just stretch in front of your chair.
panic, panic. Oh, the noise. Oh, okay, they muted it. That was very loud for the noise machine. Let's see. Oh, man, Denise, have a great drive to your appointment. Hope it goes well. This, listening to this while driving would have me rolling. I'd be like, what is going on in the court? I'll try to, right now they're just up at the bench, but if I see anything funny, I'll try to say it out loud so you know what's going on. Amber, thanks for the 10 here. A lot of discussion in the chat about the Pike County Massacre trial. It's really interesting to see thoughts from those who've seen that and are aware. So this judge, as part of that trial, made a big mistake that caused things to get overturned and turn into chaos is what I'm gathering. And of course now I want to watch that. So, and Amber's not the only one. Several others are in the chat like, yeah, he messed up big time there. And overall, it just seems like, I don't know, I get the vibe he wants the jury to ultimately side with the plaintiffs here. It's just the vibe that I'm getting. It might not be the case. It's just how I feel. Allie B from Tennessee becoming green. Thank you so much. It's super fun to become green today because, you know, it's St. Patrick's Day. It just seems like the right color. So thank you so much for becoming a member. I know you've been a member before, so we've got to tack on I don't know, like 6-7 months. Betty, thank you for becoming a member and being a member for 4 months already. Super awesome. I'm glad you're here for the Afroman trial because I don't think we'll see anything else like this for some time. Matt, but not Cat says, I'm going to become a new member. I'm going to become green. Thank you so much. Did you make bread in your picture? Is that some homemade bread? Because I love homemade bread. So tell us about your recipe if that's what it is. And then Moses with the 20 saying money for nothing and pound cake for free. Gotta do the double take though. Always gotta do the double take. So if you guys didn't see, we do have some fun channel emojis for this trial. We've got a picture of Afroman. We've got the lemon pound cake going. Use it to your heart's content. It's not something I can make available to non-members. YouTube locks it as a member-only feature, and I can't change that. But you could always use the lemon and the cake emoji to do the combo. We'll know what you mean. We'll know what you mean. We've got, let's see. We've got, aw, super nice, Christy here, gifting 5 gifted subs. So that's 5 more people that get the lemon pound cake. So thank you so much, Christy. Always showing so much love and always bringing so much insight to the chat, no matter what the case is. So good to see you. Thank you so much for the generous gifting for 5 members in the chat. And yeah, so guys, if anyone's tuning in late, like late as in you didn't even watch this yesterday, day 1 was really short. I say watch live with us. You didn't really miss much. You watched 2 of the officers that were addressing certain claims. You watched the guy that initially counted the money and never sealed the envelope. You missed Lisa, who I'll let you go back and watch that, but I don't think you'll miss any context moving forward if you watch live and then watch that later. It was only like 2.5 hours of court footage yesterday because I started after jury selection. So I vote, watch day 2 live with us, catch up on day 1, maybe during the lunch break or this afternoon. I don't think you'll have a hindered understanding if you don't work backwards. So stay live with us, stay with the chat, because the chat, it's not me. I'm just the host. It's the chat that really makes this fun. And Jenny, just Jenny, that's me. Thanks for becoming green. Thank you so much.
Go ahead. Thank you.
I asked for just to refresh, Mr. Estep, this is your body cam from that date and time we talked about earlier?
It's a body cam. I mean, I can't identify the person. I mean, the number, let's see. Not sure. Can't.
When you say number, there is a number there? ACSO?
Okay, yes,
So that is your body cam?
yes,
And this is of 8/21/22?
yes.
So you see you want to flip something? Or your maze. CDs.
I'm going to stop it for a second, just for the sake of context, as there is things happening sort of below the camera.
Mm-hmm.
Were you searching through CDs
Yes.
and DVDs?
I looked at them. I didn't like really search through them.
But that's what you're looking at right now.
Yeah.
I know, but I looked at that stuff because some of the stuff I think was mentioned in there. Well, he just denied it. So,
On your body cam during an official search, you called Mr. Foreman a sex addict?
I couldn't clarify. I heard addict. I couldn't clarify.
Would you like me to replay it?
Yeah.
Mr. Vite, can we turn up the volume? For the sake of the record, since this is roughly about a little under 3 minutes long, we're going to just back up and play something. We really shouldn't let me touch anything technology. I shouldn't break it by touching it. Thank you, Mr. Vice. So, for the sake of the record, I'm going to start the playback at 33 seconds in.
I know Brian probably looked at that stuff because some of the stuff I think was mentioned in there. Well, he's just denied it when he comes to sense.
Mr. Estep, do I need to play it again?
I still can't decipher it. I mean, whatever.
Can we get the hearing aids from Mr. Estep? Mike, we're going to give you a hearing here. This
That could be
should have a
good.
better thing. Can you hear me, Mr. Estep? Is it too loud for you?
Mm-mm.
For the sake of the record, I'll start at 31 seconds in.
You'll turn that down.
It's us.
There's a dial on your...
When I blare the volume at you guys.
Right here and there.
Center?
Right. And try to.
Did you be ready, Mr. Estep? Okay, we're starting at 38 seconds in after stopping.
I know Brian probably looked at that stuff because some of the stuff I think was mentioned in there. Well, he's just denied it when he comes to sense.
Were you able to hear at that time, Mr.
Yeah.
Estep? Would you agree that you called Mr. Foreman a sex addict?
Yeah.
You would agree that this is a public record?
Yes.
So the body cam is available to the public?
Upon request.
Okay. And Mr. Foreman cannot edit any of it, can he?
No.
Do you believe how you do your job duties reflects on your reputation?
Yes.
So someone seeing this could reflect badly on your reputation based on what you did?
Possibly.
this is going to be very stupid questions, but Mr. Klingler referred to previous posts when he was asking you about how they affected you. Did any of those posts name you by name?
No,
They just referred generally to the Adams County Sheriff's Office.
yes,
So you're just seeking damages based upon what he said about the Sheriff's Department?
no. It's what's been directed to me.
What was directed to you?
Being called a thief?
Okay. Other than that, anything else?
No,
Was there a direct post of you being called a thief?
no, just directed by the people in the community.
I'm going to get your steps in today, Mr. Foreman.
He looks like he regrets being part of this now that it's public and happening. Oh my God.
Mr. Estep, I'd like you to take a look at the screen in front of you. You're going to see what's been marked Defense Exhibit C. Have you seen that post?
Yes,
And
Look at
that
the
is
comments.
Singular post that Mr. Foreman made in reference to you, correct?
yes,
Where you were called, and I quote, Colonel King Kong Bundy.
yes,
King Kong Bundy was a wrestler, correct?
yes.
Damn good one, correct?
Damn
I
good
don't
one.
know about that. I can't answer that.
There was a t-shirt made calling you King Kong Bundy, correct?
Yes,
You told me about an incident where a friend of yours made a joke about that, correct?
wasn't a friend. It was one of the fire department that I was chief of.
One of them wore a shirt to the Christmas party?
Mm-hmm.
They thought it was a joke, correct?
I don't know if they thought it was a joke. I mean, I don't know what the true intent of it was, but they wore it. I saw it.
Have you ever had jokes made at your expense?
Oh, yeah.
Made jokes at other people's expense?
Yeah,
So it's a reasonable assumption they bought it as a joke against you?
I would hope. But it's not a good joke.
Yeah, it is. Sir.
And I'll wrap up that day. So after the search, you went home, correct?
Yes,
And you left directly from the search to go home?
yes,
After a 19-hour shift?
yes.
No further questions, Your Honor.
Mr. Klingler, go ahead.
Thank you.
Oh man.
Mike, what's your wife's name?
Renee,
How long have you been married to Renee?
since 2000, I think 2000.
Since 2000,
Yes,
26 years?
yes.
Did this felony that Mr. Osborne brought up occur before or after this search?
Long before.
Long before?
Yep,
Did you stay married to Renee in spite
did.
of this? Do you think her problems with this felony hurt your reputation?
no. I never got no backlash. I wasn't a part of it. I didn't support it. You know, she paid the consequences and she moved on with life.
And you're
Is
still
that-
with her?
I'm still with her.
Is that how you view all convicted persons, or just your wife gets an exception that they did their time and leave them
This body
alone?
cam footage that we saw, did you ever publish that body cam to the world?
No,
Did you ever post that body cam on the internet?
no,
Did you ever share that body cam, and specifically that part of the body cam where you refer to Mr. Foreman as a sex addict. Did you ever share that with anybody?
No.
We saw, Mr. Osborne just showed you a post of you being called hunchback or something.
King Kong Bundy.
If Vince would like, we can put it back up so he gets the term correct. There is going to be specific names for specific people, and we need to keep things as orderly as possible as to who's called what.
What did he call you in that?
Colonel King Kong Bundy.
Thank you, Colonel King Kong Bundy. Was that post made in the context of all these other posts that call the sheriff's department thieves?
Yes.
Those are all my questions, thank you.
Okay. Have you tried the lasagna?
Mr. Estep, look at what's been marked. This is the post where you're called King Kong Bundy, correct?
Yes.
Does it call you a liar? Strike that. Would you read the entire post?
It says, "Good morning, ladies. This guy was easy. Introducing Colonel King Kong Bundy. LOL. Let me know if you have a nickname better than mine. What you got?" And then
So, well, you don't need to read the rest. I'm just
Okay.
worried about Mr. Foreman's statement.
Okay.
So he didn't call you a liar in this post?
No.
Didn't call you a thief?
Nope.
So all the other posts that you would refer to are solely about the sheriff's department being called thieves?
Yes.
Your Honor, if I may have a sidebar?
Yep.
Oh, sidebar. Yeah, you gotta dismiss this guy from the case. Like, what is the claim even? Like, you can't comment on dishonesty of cops? Oh, the way the sound cut out made it feel like I was yelling, sorry. Oh boy. We're gonna see if we can bring something in. Whisper, whisper, whisper. Afroman's just spitting in his chair. Lisa's rubbing her forehead. This guy's in the back laughing, I think. There's water everywhere in this courtroom. Like, what is going on? They are prepared. You never know. Look at all this. There's more water bottles in this courtroom than people. Also, just Jenny, that's me. Yes, I know. Jenny, not from the block. It's very fun to have the YSL trial watching crew come back together for this one. And all the new people, right? We're growing the gang. Growing the gang. Watching more ridiculous trials together. Same. I think it's like great attire. It's like the whole thing just feels like a music video. Just, there's no music to it yet, but maybe there will be.
So, Mr. Osborne's finished. This witness is going to step down. We're going to take like a morning break.
Oh.
For good work so far.
Hopefully we get to watch.
Enjoy yourself. We'll be back in about 10 minutes.
I think this looks like Ryan Applegate, who is a reporter with, it seems like a local, like an Ohio-based publication called The People's Defender. So I think this is one of the guys that applied for a media request as well. So good to see coverage of this trial in the courtroom.
You just pack some dimes around for this bad boy.
What is the noise?
It's like a cuss jar.
Okay, I looked at it, I get ready to use the staple,
Go right ahead,
and try to get dime again. I just want to make sure you're counting. I don't want to steal a dime from you.
Oh my god, the laugh. Alright, let's see. Yeah, so maybe it looks like they're actually leaving and taking a break. I was wondering if maybe they'd argue something. And it's still unclear if we're going to be able to see any outside the jury presence stuff. So we'll get up to real time. Oh, jeez. I'll run this in the background, and we can continue reading that motion in limine that we were in the middle of, and we'll come back. So we were in the middle of reading Mr. Osborne's, so attorney for Afroman, his response to the plaintiff's request, their motions in limine that they filed a few days ago, to exclude, among other things, the lemon pound cake video and the will you help me repair my door video. We just read the arguments. They were kind of hilariously penned at the beginning of the stream for the lemon pound cake. And now we're going to see the response to plaintiffs not wanting to include the will you help me repair my door video. Also, wait, hold on. Wind, thank you for being so generous and gifting a membership out here. Thank you, thank you. We've got, similarly with the song, Will You Help Me Repair My Door? This song depicts the actual search of Mr. Foreman's residence. So for context, remember, plaintiffs' motion in limine, they want to exclude something. Their argument was that the lemon pound cake video and Will You Help Me Repair My Door is not relevant to any of the claims in this case, nor any possible defenses that Afroman could raise to any of the claims in this cases. They say it's not relevant. So this song depicts the actual search of Mr. Foreman's residence. It shows the defendant's contemporaneous observations and reactions to the events, which is directly relevant to whether his statements were true or whether he had a reasonable basis for making them. Plaintiff's defamation claims arise from defendant's statements about the search warrant execution. The music videos depicting that very execution provide essential context for understanding those statements. Without this context, the jury would be asked to evaluate defendant's statements in a vacuum, divorced from the circumstances that gave rise to them. The videos are also admissible to show defendant's state of mind, his basis for making statements, and the circumstances surrounding the incident. This is particularly important in a defamation case where defendant's intent, knowledge, and reasonable belief are relevant to the jury instructions that will be given in relation to actual malice. Thus, the songs are evidence as they have any tendency to make a fact of consequence more or less probable. Rule 402 says that relevant evidence is admissible. No analysis of how the songs would confuse the jury is given. So we read that motion over the weekend. It just said it's irrelevant and it would exclude the it would confuse the jury, and that was it. After all, to raise the issue of confusion with the jury, one must show that the offered evidence would require the trier of fact to engage in intricate, extraordinary, or impossible mental gymnastics in order to comprehend the import of the evidence or to assess its weight. I feel like I have to do mental gymnastics to figure out how the plaintiffs could even argue that these two videos aren't relevant. Not just because of knowing the overall context of why this case is here to begin with, but they also mention both of these videos multiple times in their complaint. So they made it relevant. So there's a footnote that's quoting State v. Martin. Strangely, the plaintiff cannot or will not articulate how a music video or song would do that. So plaintiff claims the video would create a circus atmosphere and belittle plaintiff's claims. However, evidence is not unfairly prejudicial merely because it is unfavorable to the opposing party. So remember, this is a video that largely, like, there's some parody and there's some stuff interwoven in between it, but it's using the footage of the raid on the home. So if something that's using footage of the raid on the home creates a circus atmosphere, it would seem like the circus, the reaction is something that's inherent to the search itself, the raid itself, and not the fact that it was then included in a music video. The videos have substantial probative value in showing what occurred during the search warrant execution, which is the central factual dispute in this case. Yeah, the central. If evidence is unfairly prejudicial because it is unfavorable to the opposing party, then all the posts that the plaintiffs seek to admit and use as evidence would be excluded. Any prejudice to plaintiffs from the video is not, quote, unfair, it's in quotes, prejudice, under Rule 403A. The videos simply depict the underlying incident and defendant's reaction to it. If plaintiffs find the videos embarrassing or damaging to their case, that is a consequence of their own conduct during the search, not unfair prejudice requiring exclusion. The Trinity White Knights flyer has been removed as an exhibit and no response to it will be provided. So that was on Afroman's exhibit list, proposed exhibit list, and there was an opposition in that motion in limine from the plaintiffs, and they're saying, look, just moot it, we're not going to bring it in. The search warrant and return, because the plaintiffs also want to exclude this information. The search warrant and return are directly relevant to defendant's truth defense. In Ohio, truth is a complete defense to defamation, and that's, oh, okay, that's just the Ohio rules of whatever. To prove truth, defendant must present evidence about what occurred during the search warrant execution. The search warrant itself is relevant to show why plaintiffs were present at defendant's residence and why they were authorized to search and seize. The return is relevant to show what was actually seized, including the cash that is central to defendant's statements about theft. Further, the return on the search warrant was completed by plaintiff Brian Newland, and he put it in the proof of the amount of cash he seized. To exclude them makes little sense when the plaintiff is planning on calling Detective Robinson to present his report about the missing cash from the search. Thus, to want to introduce evidence of an investigation and then want to put limiting instructions on the defendant's counter evidence is an attempt to render any defense impossible. Without analysis on how the search warrant and return on the search warrant are not relevant evidence or how it will confuse or mislead the jury, the plaintiffs ask for limiting instructions in relation to the evidence. Plaintiffs request that the court instruct the jury that, quote, the warrant was legally valid, lawfully obtained, and lawfully executed, and that the contents of the warrant and the way it was executed are not issues for their consideration. I hate this because this kind of gets into the idea that, well, it's lawful, so any criticism, public response to what the law enforcement officers were doing would be inaccurate. It'd be a misstatement because it was lawful. So this proposed instruction is improper because it would direct a verdict on factual issues, yes, that are central to defendant's truth defense. Whether the warrant was properly executed and whether plaintiff's conduct during the execution was lawful are factual questions directly relevant to whether defendant's statements about their conduct were true. The court cannot instruct the jury to accept plaintiff's version of events as true. That would usurp the jury's fact-finding function. In fact, let me double check where we are in court. All right, they still got music going. So they're on break still. All right. In fact, the Honorable Fourth Appellate District has held trial court generally has broad discretion to fashion jury instructions. However, a trial court must fully and completely give the jury all instructions which are relevant and necessary for the jury to weigh the evidence and discharge its duty as the fact finder. Additionally, a trial court may not omit a requested instruction if such instruction is a correct, pertinent statement of the law and is appropriate to the facts. Juries are presumed to follow instructions at a trial court, and a trial court is not required to give a proposed instruction if the substance of the instruction is already covered by the general charge to the jury. The plaintiff has failed to articulate how the special instruction would be needed due to a failure of the general instructions to adequately address the legal principles at issue. The plaintiff must complete an analysis to support their position, not just make baseless assertions about relitigating counterclaims. The plaintiff knows that the counterclaims are not at issue at this time. That issue rests with a future filing with the 4th District Court of Appeals. Yet the plaintiffs keep failing to do any analysis and just asserts baseless assertions at the defense. The plaintiff indicates that the body cam has only limited relevance and thus must have a limiting instruction. It has relevance to the plaintiff. They have listed it as an exhibit and will be calling Detective Robinson as a witness, who will testify that he viewed the body cam footage of the counting of the money as part of his investigation. Strange that the plaintiff's limiting instruction is tailored to paint evidence in their favor with the jury. Yet, why is limiting instructions necessary? The body cam footage is relevant to the defense in multiple ways. It is an almost limitless source of impeachment evidence against all the plaintiffs who were deposed. An almost limitless source of impeachment. I mean, yeah. After all, while the counterclaims may not be at issue, the truthfulness of the plaintiffs will be. Even more so now that the plaintiffs are claiming damages to their reputation. The defense shall present evidence that the plaintiffs were less than truthful during their depositions. The events they described and answers to specific questions were answered with outright fabrications that are not supported by their own body cam footage of the event in question. Yet this is not the only evidence that would come from the body cam footage. A similar argument can be made for the body cam footage that was made for the music videos / song discussed above. The plaintiff has again failed to complete an analysis for the need of limiting instructions. Rather, they assert that the body cam can only have one use, the use they desire, and they want the court to instruct the jury accordingly. That position fails, as without an analysis to show how the jury will be confused, no limiting instruction is proper. Nor is it proper, as it would limit the defense from presenting evidence that would serve multiple purposes for the defense, not just impeachment evidence. Similar is the Adams County Sheriff's Office policies and procedures, because plaintiffs don't want this coming in either. So we've got, they show the correct procedure for the execution of a search warrant and the handling of cash evidence. The plaintiff all but admits that Plaintiff Newland did not follow the policies and procedures. All right, we are back in court, you guys. Abruptly.
You're referring to the general reference? I asked you about all exhibits
Yes.
previously. And
This is the other Shawn, I think.
so when you're referring to those exhibits that he's presented for, you're referring to the general ones that talked about the Adams County Sheriff's Department as thieves?
Them and some of the posts that was on about me personally. Pardon me?
What kind of things?
Ones that was just been posted
Okay.
within the last few days.
So, okay.
I think this is Shawn Grooms.
And
He's a
you've been in
deputy with
law
Adams County
enforcement
Sheriff's.
between the West Union and Adams County Sheriff's Department for 21 years.
Correct.
And you've arrested a lot of people.
Yep.
Okay, you have to verbally, because a shaking of the head doesn't get
Yes.
recorded. And you've been criticized before for your job duties?
Yeah.
And you've been called names before?
Yeah, but not a thief.
No person ever before has called you a thief in 21 years?
No, they have not.
And you were employed with the Sheriff's Department on 8/21/22?
Correct.
And you took part in the search of Mr. Foreman's residence?
Correct.
Did you ever encounter the money?
No.
Did you ever see it?
No.
You were never present in any room when it was being counted?
Not when it was being counted.
But when it was maybe sitting on a table or something?
No.
Do you ever remember seeing the money during the search?
I seen some when they pulled it out of some of the pockets.
So you were there when they pulled the money out of the pockets?
Yeah.
And that's all you saw in
That's
reference
all
to
I
the money?
seen.
So your job duties were other places during the search?
Yes.
Have you ever been disciplined due to anything Mr. Foreman said?
No.
Reprimanded in any way?
No.
Were you ever interviewed as part of this investigation into the missing money?
No.
Is it true that Mr. Foreman called you a hunchback
Yes,
and specifically compared you to Quasimodo,
yes.
the Disney hero?
I'm assuming that's who it is.
Quasimodo from the Disney movie The Hunchback of Notre Dame?
I've never watched it, so I don't know.
So you would agree that when a person says that someone's a crooked defense attorney, they're not meaning that I'm like a vine, they're meaning that as a opinion, correct?
Correct.
Would you agree that when someone calls you a thief, it might be an opinion of theirs?
Can be, yeah.
Same as if when people say crooked cops, it's just an opinion?
Yeah.
Well,
And so is your entire claim for false light that you were called a thief?
Yes.
And you would agree that Mr. Foreman is an artist, subject to exaggeration?
I guess so, yeah.
And just for the sake of question, nobody would ever think you're Quasimodo from the book, correct?
I don't guess. People think different things.
Have you ever taken a chance to talk with the local newspaper, the People's Defender or Informer, to tell them your side of the story?
No.
So how long before you filed the lawsuit through your attorney did you send the cease and desist letter to Mr. Foreman?
It was whenever he sent it. When my attorney sent it to him.
So you never sent a cease and desist letter before the lawsuit was filed?
No.
And you're seeking damages due to your reputation, correct?
Correct.
Your reputation in the community locally.
Correct.
Okay. So you don't care what people think of you in Australia?
Not really.
Would you agree that everything you do as an officer reflects on your reputation?
Yeah.
All the good and the bad?
Yeah.
Anything wrong you would have done would be a stain on it?
Yeah.
And you mentioned that people had came up to you in public and called you a thief, correct?
Yes.
You've been criticized for your job duties before, correct? By the public?
Kind of, yeah.
People have said they didn't think you did things right?
Yeah.
And they have a right to criticize you for how you do your job?
Pardon me?
They have a right to comment on how you do your job?
Yeah.
Did you wear a body cam during the search?
Yes.
Can I have a second, Your Honor?
Go ahead.
Your Honor, I have no further questions at this time.
Go ahead, step down, thank you.
So another, like, why are we here?
Lady's called Shawn Cooley.
Oh, is this pound cake? Oh my God.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? As this, you shall answer unto God.
I do.
Thank you. You may proceed.
Okay, go ahead.
They zoomed in on him.
Introduce yourself, please.
Shawn Cooley,
How is Shawn spelled?
S-H-A-W-N.
Thank you.
And Mr. Cooley, are you currently employed?
No, sir, I'm retired from the sheriff's office.
When did you retire from the sheriff's office?
I originally retired in 2014. The sheriff, then Kimmy Rogers, asked me to come back a couple times. So eventually I did, and I worked up until about 2 months ago.
So up until 2 months ago, you were back as a deputy sheriff?
Yeah, I started out as a part-time deputy, and then as their manpower dropped, I went ahead and took a full-time position to help them for a while.
And that's here in Adams County, correct?
Yes, sir, it is.
When did you begin with the sheriff's department? Sheriff's office?
It would have been late 80s, early 90s.
Okay, long time ago.
Long time ago, yes.
Do you have family here in Adams County?
Yes, sir, I do.
How long have you lived in Adams County?
Over 40 years.
And one of your family members is Justin,
Yes, sir, that's my youngest son.
and he's another plaintiff in this case.
Yes, sir, he is.
You worked with him for a while in the Adams County Sheriff's Office?
I think that was shiny
Yes,
head
some I
guy.
did. Most of the time we were different shifts.
Okay, but I meant you worked
Yeah,
for
yeah.
the same sheriff's department for a while?
Absolutely,
Yes.
yes.
Are you married?
Yes, sir, I am.
How many children?
4, 2 girls and 2 boys.
Did they go to school here in Adams County?
Yes, sir, they did.
Shawn, do you remember giving me a call back in late 2022?
Your Honor, I'm going to object here. I do believe he's starting to move into the realm of attorney-client privilege and opening that. If he opens that door, we do intend to exploit it. And so we would just give the court notice that's what we believe is happening at this time.
Thank you for the heads up. See where it goes.
Thank you, Judge. Let me ask the question this way. Were you looking for an attorney in the fall of 2022?
Yes, sir, we all were.
And just in a nutshell, what were you trying to accomplish by contacting a lawyer?
The posts and the things that were put on the internet about us, as far as us being thieves and different things with our image. We had went to the sheriff when this originally started. Mr. Foreman had an attorney, well, he's had 2 attorneys prior to this one. We had the sheriff contacted, tried to get it stopped. Then again with the next one, then again with this one. So our only other alternative was to try to file some kind of suit.
And that's why you ultimately decided to file suit to get it to stop?
Yeah, that was our last alternative.
Has it stopped?
That's gotten much worse.
I mean, because of the suit.
You were part of the team that executed the warrant on Mr. Foreman's property?
Yes, sir, I was.
Did you steal any money?
No, I did not.
Did you have anything to do with the money that evening?
The only thing I had to do with the money, I sat in the kitchen and talked to Mr. Foreman's wife.
And looked at the
Mr.
cake.
Foreman's wife, Angela?
Yes.
Now, let me just stop you
Or
there.
ex-wife.
Oh, thank you. Ex-wife. Let me stop you there for just a second. How did Angela Foreman end up being in the kitchen of the home that evening?
I don't know which supervisor it was that let her come in.
Your Honor, I'm going to object to this line of questioning.
if the search warrant is not going to be an issue, if we want to open that door, then I will ask to present that evidence and make that case, but Mr. Klingler now wants to bring up who everybody is there, so if he wants to open that door, I'm going to ask for the same latitude upon my presentation of the case, and I think the court has already made it clear, we are not litigating a search warrant.
I'll withdraw the question. I don't need to know how she got there, Judge.
Just for everybody's benefits, they both pushed beyond what I was willing to do, so let's try to keep it focused. Thank you for withdrawing the question.
We got to yell at
Thank you,
both
Judge.
sides.
Again.
You were explaining what you had to do with the money that evening, so go ahead.
Put it on
I
his
was
head.
sitting in the kitchen on a stool, I believe. Brian Newland brought in a package that he said contained money, laid it there, and asked me to keep an eye on it.
Okay.
And
Who was in the kitchen? Sorry, who was in the kitchen with you?
Mr. Foreman's wife,
Okay.
or ex-wife, I'm not sure.
Just
what
the two of you
status is.
at the time?
Oh, there's people in and out.
Other deputies?
Other deputies coming in and
All right.
out, going back and forth to their cars to, you know, to get different items. Sergeant Walters came in at one time and talked to Mr. Foreman on the cell phone.
Okay. So, back to the cash. You were asked by Detective Newland to keep an eye on it, and what happened then?
Well, that's what I did, and then a short time later, Mr. Newland came and got it and secured it somewhere.
And that was the extent of your...
Yeah, I never touched the
Contact.
money, never was even really close.
All right. Now, you mentioned earlier your reason for contacting a lawyer in this case. I want to just jump ahead right now to how these posts that referred to you and the other
Here we go.
deputies as thieves, has that affected your reputation in the community, do you believe?
Absolutely, there's no doubt it has.
Well, tell us what makes you think that.
You know, to understand that, you got to go back before this happened. We would go on calls, you'd very seldom ever have any trouble at anybody. Very, very rarely. You might get a drunk that was smart off or something of this nature. Then he starts calling us thieves on the internet, starts selling merchandise with our photo on it. So now when you go into a bar for a call, you've got people in there screaming, hey, you gonna steal all of our money, you know, or you go on a call. I had one guy come out of a bedroom after me, call me a thief and wanted to know why I sold Afroman's money. It just went from being a nice, quiet community, a job you felt safe in, to a place where you had to look over your shoulder every second.
Do you, based on what you've explained and what you've been through, do you think some of these people who called you thieves really thought you were?
Absolutely. Absolutely.
Did you receive any phone calls about this?
I would answer the phone at the sheriff's department because they were overwhelmed. I remember one day there was over 300 calls threatening us, calling us thieves. So we would have to go over and help dispatch because they were overwhelmed. There's only 2 dispatchers. So yeah, they didn't call me directly, but I answered the phone. They would cuss me, threaten to kill me, threaten to kill my kids, threaten to kill my wife. And it got to the point to where my wife and my children couldn't even go to Walmart.
Oh,
They
no.
couldn't go into a gas station around here. My youngest daughter would hear the dogs bark at night and come in my room, wake me up terrified that somebody was there to kill us. Because even though they were young, they're still on Facebook. They still see this stuff. And it was just one after another after another. And when it would start to slow down, he would go back and do it all over again and get it all started again.
Because you have a
Just like you
lawsuit
did.
going.
A couple days ago.
Are you aware of posts that are continuing to come out as recently as yesterday?
Some I are.
I'm going to put my objection in place here. It'll take a second. So Ohio law has changed since April of 2025, providing more protections under the anti-stalking. With that, we would have a 60-day notice
So
of
I
any evidence.
sustained your objection, you can sit down, thank you. Like at some point in time, we draw the line, I just drew the line. of
Oh my
what's
God.
Evolving in the public, like we started this trial yesterday, so let's try to stay before yesterday. You're all doing a fine job.
Thank you, Judge.
Fluid,
Yep.
but the trial can't be that fluid.
The cake.
Same.
Are there any other examples that you can think of as you sit here today of ways that these posts about being a thief have affected you in a negative way?
One of the things that really kind of upset me, I was doing an investigation as a detective, and I had to go all the way up to eastern Ohio on the Pennsylvania border. And when I walked into the deputy's room up there to talk to them, they all knew me, all knew that I'd been called a thief, lemon pound cake. You know, it's everywhere. You can go anywhere, and if people recognize you, they start that stuff, whether they're being sarcastic or what, but.
And has your image, your face been posted on some of these posts along with, or in the context of the thief accusation?
Well, according to he has posted my image, yes, several times on the internet. He's sold merchandise, sweatshirts, T-shirts, things of that nature at all of his venues. Matter of fact, they were for sale at a smoke shop here in town.
Okay. Those are all of my questions. Thank you.
Thank you, sir.
Cross-examination.
Here we go. Frosted lemon pound cake. Oh, carrying the cake over to the stand.
Shawn, for the sake of the record, we have to keep things straight because there is another plaintiff named Shawn.
Absolutely, yes, sir.
Can we call you Lemon?
Do you mind if I call you Shawn or Shawn Cooley during this time?
Whatever you'd like. Well, let's rephrase that. Yeah, that'd be fine.
I like to pick right up with this visit to the Pennsylvania border. You said they knew you as Lemon Pound Cake.
Yeah, that was what they referred to me as, a person.
And they asked you for your autograph, correct?
One of them did, yes.
And so,
Your Honor, if we could have a sidebar about the Exhibit D that defense intends to exhibit.
Is this lemon pound cake? Let me look. Let me look. It's got to be lemon pound cake. Oh my God, there were so many files. All right, the amended exhibit list. Ah, it logged me out. Come on, Docket. We'll probably find out before it lets me go past this CAPTCHA. They are arguing. This is not a quick little yes or no. Yep. Well, number 4, which would be the 4th letter of the alphabet, which would be D, is music video song Lemon Pound Cake. So, yeah. So there we go. If they're using the alphabet in order. This is David Osborne, is the attorney for Afroman. He's a delight. I like Mr. Osborne. Also, let me give a shout out. May sent over a Cash App. Thank you so much. I did miss it. I'm sorry. Big thank you. Always appreciate it. And it's good to see you in the chat. I hope you've been doing well.
You can go ahead with Defense Exhibit E.
Yes! Yes! Let's go, chat!
I don't think we'll have to stop this one.
It's coming in.
Let's eliminate all doubt.
I'll ask a couple of questions. So, Mr. Cooley, sorry, Shawn, you were
Called Officer Pound Cake by Mr. Foreman?
Multiple times.
You
You
are-
received hundreds of pound cakes at work from different people.
Okay. And the context of that name comes from a music video that Mr. Foreman created, correct?
I don't know where he got it at, but you'd have to ask him that question.
Well, I'm going to play what's marked Defense Exhibit V. I'd like you to watch this.
Okay.
Oh, you gotta turn it on. Oh. Stop it there.
Stop it there. No.
So you've seen Exhibit D, correct?
Mm-hmm.
You would admit that's you with the glasses walking by the lemon pound cake on the counter?
Yes.
And that is security footage from the search of Mr. Foreman's residence?
I assume, yes.
But there's no question that's you during the search?
Yes.
There is question or there's
No, that was me, yes, absolutely.
So during the search, Mr. Newland asked you to watch the money,
Correct.
and you watched that money until he came back and got it.
Absolutely.
I'm gonna play what's gonna be Defense Exhibit E. Is it like a side block?
Oh,
Right there.
the body cam footage. Hold on, I gotta make another picture because his head's moving too far over. He's leaning. After having to watch this video, his lean is like extra to the side now. Oh man. So I dropped the link in the chat. It's also in the playlist if you guys want to listen to Lemon Pound Cake anytime at your leisure. It's something that'll probably be stuck in your head. It's a link there. So, and I would imagine the views will probably go up on that video because it'll probably get some renewed attention today because of this lawsuit. It's currently at 3 million views. Oh man. I love this angle of the court. Alright, so there we go. Body cam is queued up.
Oh, you didn't?
No.
But you were caught on body cam that time, right?
What do you mean caught?
So other officers who wore body cam, you would be seen on that body cam, correct?
Yes. So if I was close to him, I would have, yes.
Oh, let me play this clip for you. So, off to the extreme left of here, we just saw a gentleman. Was that you?
Yes, I believe so.
So you are in this body cam footage.
Could you run it back just a second and let me see?
Let me start it over.
Okay, that'd be fine.
So, just for the sake of the record, we see two people in this video. Do you know who the lady is?
Yeah, I believe that's Mr. Foreman's wife, ex-wife.
Who's the other gentleman in the doorway?
I can't tell, but I don't know.
Would it appear to be Kenneth Dick?
It could be, it's just not,
I just, well, actually, maybe look at this. I think this is a better image of it. than
Yeah, it
this
does
one.
appear to be, Kenny, yes.
Because it is dark on my screen here. Okay, so on the extreme left, we see a gentleman there. Is that you?
Yes, it is.
And this would be during the search of Mr. Foreman's residence, correct?
Yes.
All right. Hey, hold on, Newland. Explain what's going on.
Let me rewind this a second. Looking at the table here in the bottom right-hand corner,
Mm-hmm.
is that the evidence bags with the money?
Yes, sir, it is.
Those were the evidence bags you were just testified to, that you watched the entire time for Mr. Newland?
It's a evidence bag, yes.
A.
So it's not the money evidence bag?
It is the money evidence bag, yes.
Okay.
It is the.
And you're watching it right now, you're looking at it?
Yes.
And you're walking outside now?
Okay.
The person's following you? Shawn, it would be a fair statement to say you didn't watch that money the entire time that Brian Newland left it in your possession, correct?
No, you are correct. But you can also hear me telling the deputy, keep an eye on that money. If you want to play
Which
it back.
deputy was that?
I don't know. I have no idea, but you can hear me and see me talking to another deputy before I walked out.
The guy walking right behind you would have been the one.
No, I was looking, the guy behind me would have been behind me. Just play it back and you'll see it.
Okay, well, let's replay.
All right. Hey, hold on, Newland. Explain what's going on.
Right there.
You said you're not worried, no one's here.
No.
Well, let's
I
replay.
believe I told him to keep an eye on the money before that.
Okay, let's play it again. Let's start at, well, let's go back to, did you agree that 0:16 seconds in? it
Yeah,
would
that's
be after
fine.
that?
Yeah. Mhm.
Explain what's going on.
Did you hear it say, what's the money?
No.
Before it
that's-
said, I'm not worried, there's no one in there.
Yeah, that's what you said.
That's why I said yes. Yes.
So the person asked you about watching money, you said you weren't worried because no one was in the place.
It does appear that way, yes.
Okay.
For the record, 35.27 to 36 minutes even. I got it.
Oh, thank you.
You're welcome.
Now, I'm going to say this. I'm going to ask a question. I do not want you to tell me anything you have talked with any attorney with Mr. Klingler or his associate. I do not want to know that. But I do want to know, you said you were looking for an attorney in the fall of 2023, correct?
We all were.
Okay. And so you employed an attorney to send a cease and desist letter prior to sending lawsuit, correct?
No.
Okay.
The testimony was fall of 2022. The litigation was filed in March of 2023, just to make it record.
Let me rephrase that then. So when I mistakenly referred to fall of 23, it was actually fall of 22, correct?
That was for the fall of 22. I'm not sure what
You started looking for an attorney in the fall of 2022.
I believe, I don't think I'm the one who made the original call for an attorney.
Okay.
It was one of the other deputies we had discussed it. We had to have permission from the sheriff at that time to do anything.
You took some of the phone calls, the threatening phone calls, correct?
In dispatch.
Yeah. Did you make a report of those?
They were all documented, yes.
And they investigated and traced the calls?
Couldn't trace them. They were all ghost numbers or showed up as no phone number at all.
So nobody was ever prosecuted? No one was called in to...
Well, they couldn't find them. They don't have any idea who they were.
But you're not saying that was Mr. Foreman making the call, correct?
I don't know whether he did or not. His rhetoric led up to it.
People, during your significant time as a law enforcement officer, the public has criticized your duties, correct?
Yeah, some, yes.
You've been called a lot of derogatory names?
Not really.
This may sound stupid, but I believe it applies to myself. We're not the thinnest people in the world, are we?
I'm not going to call you fat, but okay.
I was calling myself fat. But you would agree that we're not thin people?
Absolutely.
And you would agree that how you conduct yourself during a search and everything reflects directly on your reputation?
Absolutely.
You don't believe everything you read on the internet, do you?
No.
You actually probably don't believe everything you read in the newspaper, do you?
No.
You would agree that Exhibit D that I played, the song Lemon Pound Cake, is a music video for entertainment?
There again, he made accusations that I smoke weed on there, which I don't.
So
that was a lie as well.
So you are suing based upon him saying you smoked weed in a song?
No, I'm just saying that
So that statement is not part of this lawsuit?
He's done.
Let's let him finish.
Okay.
I said that goes along with some of the other rhetoric that he's told about us, lies he's told about us.
Okay. Could that be exaggeration to make the song funny?
I don't think it's funny.
Would a reasonable person listening to that believe that Mr. Foreman is stating facts?
You don't know what somebody's thinking. You wouldn't think we'd get 300 calls a day threatening to kill us. Somebody's buying into it.
So when Jerry Reed sung the song, "When you're hot, and when you're not," and the judge said that to him right before he sentenced him to prison, that's an actual fact, or is that a exaggeration
So
for
we're going to
entertainment?
strike all that because we don't know anything about that case, and he's not going to become a witness.
Put the cake on the judge.
So until you establish a foundation that he knows what you're saying, you don't get to testify. So set it up right, I'll let you do it.
Mr. Cooley, what is your favorite genre of music?
Food music.
60s.
Give me an example of a song.
Free Bird, American Pie.
Let's take American Pie.
Leonard Skinner.
Is the song American Pie, you've listened to it, correct?
Multiple times, yes.
Is it literally about a pie?
No.
It's more about something else.
Yes.
It's for entertainment.
Yes.
And you were entertained by it.
I like the lyrics, yes.
And you don't, in that song, American Pie, do you believe that was fact?
That what was fact?
What was said in that song?
No.
this may sound stupid, but when people talk about dirty defense attorneys, are they just saying I didn't wash my suit, or are they exaggerating?
I don't know what's on their mind.
It would probably be an opinion, though.
There again, I don't know, maybe they know something on you.
Like I didn't take a shower that day?
Yeah, that, or you've done something you shouldn't be doing.
Oh,
So when a person yells crooked cops, they may be just referring to cops in general doing bad things?
that they shouldn't have been
Could
doing.
be.
Okay. Expressing their opinions about what they think?
They could be, yes.
Okay. So, I'm going to get this straight. So you're saying that being called Officer Pound Cake has colored you in a false light, correct?
No,
Okay, so being called Officer Pound Cake has nothing to do with this lawsuit.
no.
So
It's in the
the only
complaint.
thing that you're saying painted you in a negative light is the general comments calling the Adams County Sheriff's Department thieves,
No,
correct?
calling me a thief.
So there's a specific post that calls you a thief.
There's photographs of me on it, and he's accusing all of us of being thieves, so that incorporates me as well.
So it refers to the Adams County Sheriff's Department as a group then, and you're part of that.
Just members of the sheriff's department, not the entire sheriff's office.
But it doesn't list your name.
Yeah, there's posts that list my name, I'm sure.
You mean you're sure?
I'm pretty sure that there was some that had my name on it. I mean, I don't recall which ones, but
We haven't introduced any to evidence by your attorney. What posts are you referring to? I need a date and time.
I don't know. I'm just saying that there could be. I don't know.
There could be, but you don't know.
Right, right.
Do you mind keeping your testimony to what you know, not what you're guessing at?
Yeah, I have been, as far as I can.
As far as you can. So in your defamation claim would be based solely on being called a thief as a group of people, and you're one of those groups.
I'm concerned about me being called a thief as well as my fellow officers.
They get their chance, let's talk about
Right,
you.
right.
Okay. But that's the sole basis of your defamation claim?
Being called a thief?
Yes,
That's the majority of it, yes.
but not being called Officer Pound Cake.
No.
And okay. May I have a second? Your Honor, I have no further questions for this witness at this time.
Redirect?
No regret.
No redirect?
Thank you, Judge.
Thanks.
Next up?
Next up is Randy Walters.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? As this, you shall answer unto God.
Yes, sir.
Thank you.
Go ahead.
Thank you, Judge. Would you introduce yourself to the jury, please?
I'm Randy Walters.
And Mr. Walters, how are you currently employed?
I am a sergeant with the Adams County Sheriff's Office.
How long have you been a sergeant?
I'm not for sure the date that I was promoted to sergeant. Been with the Sheriff's Office since 2010, I think it was.
Since 2010?
Yes,
How long have you lived in Adams County?
my entire life.
You went to school here?
Yes,
Do you have family here?
yes I do.
You have a wife and children?
I have a wife, 4 daughters, and 2 little boys, or 2 sons.
So 6 kids altogether.
Yes.
Are all of those your own kids?
We are a little bit of a mixed bag. I have 3 biological kids and 3 children that I adopted through foster care, yes.
What are the ages of your children?
My little boy, who's biological, is 10 years old. My next daughter is 14 years old, who is adopted, and I have a 17-year-old that's adopted, an 18-year-old that's adopted. My 22-year-old son is biologically mine, and my oldest daughter, who's 26, is mine. They're all mine, but biological and otherwise.
Yeah.
And I've had the girls since my 14-year-old was about 2 months old.
And this will become relevant, I think, just a little later, but I'm going to ask you about the race of your adopted kids.
So 2 of my adopted daughters are biracial Hispanic, and my youngest adopted daughter is biracial African American.
And your youngest is the 14-year-old?
Now she's 14, yes.
And in the fall of 2022, she would have been
Around 11, I think.
around 11 or so? How'd you get into law enforcement?
My father was a police officer, and it's just something that I've always worked towards doing.
And you're the rank of sergeant right now?
I am.
And you took part in this search of Mr. Foreman's home back in 2022, is that right?
Yes, I did.
Can you tell us just a little bit about what your role was in that search, just generally?
I was called in to assist with the search, and you have what's called an entry team. I was asked to come in and help with the entry team on the search.
Did you have anything to do with counting or keeping the money that night?
No.
Have you been accused of stealing money from Mr. Foreman's home?
Yes.
Can we look at Exhibit 27, please?
Oh,
Before we, I don't know if we can do this, Natalie, but can we see the date and the number of views on this?
It's in the bottom. It's really hard to see with the way that the media playing system works because it's blocked by this gray bar, and the gray bar doesn't go away while it's paused.
All right, so well, let's just play it and see what happens. Thank you.
I pay taxes, I work daily, I get rated by Beetle Bailey, Randy Walters, Private Pie, I used to fuck his wife, doggy style.
damn.
Could you see anywhere on there the date on this video?
It says 3 years ago, 727K on the views.
So it says 3 years ago, that would have been sometime in 2023, I guess, and did
Your
you...
Honor, I'm going to ask, is there a specific date and time on this?
This one, just with the way that it played on YouTube, it doesn't show the specific date, but I can represent that it was the 23rd of October 2022.
I would object to you representing Your Honor.
Okay.
So we don't know the exact date from this image when it was done?
From this image, no.
Okay.
2023.
3 years ago, and did you say 727,000 views?
Yes.
All right. Now, we have 3 other exhibits that show the same clip on different platforms and dates. Is that right, Natalie? I'm just trying to figure out the most efficient way to do this. Can you bring up Exhibit 28 and just show us the first slide?
I pay taxes, I work daily, I get rated by Beetle Bailey, Randy Walters, Private Pie, I used to fuck his wife, doggy style.
All right. Now, when do we know when that one was posted? Can we see that?
I cannot make out when that one was posted, no.
Can you tell what platform that was posted on?
That's on YouTube, and it seems like 974,000 views.
All right. And is there any indication of a date that you can see?
Not with the words it's covering it up now.
We'll have to figure out how to do that, because it ought to be doable.
Well, yeah.
All right. Can we go?
October 4th, 2022.
Don't. Oh,
You find it?
Yeah, when it was, it says down below it, October 24th, 2022.
October 4th?
Whatever she did, it took the line down and you can actually see it.
It doesn't go away while the video is paused, it has to be playing for the volume.
You have to play the whole thing again, so let's don't do that. Well,
It didn't go away this time.
let's see if it'll go, there we go.
October 4th, 2022, 512, 574.
Thank you.
On the views.
October 4th, 2022, we got a date on that. Let's go to Exhibit 29. And before we, okay, do we
The
know
comments.
what, can you tell what platform this is?
It says Instagram.
Instagram, and can we find a date?
I couldn't even tell you where to find one on Instagram on that.
All right.
So, well, October 4th, 2022, it says right here.
All right, so,
Your Honor, he says right here, could they please indicate where that is in this?
Yeah, you'll see a logo on the bottom corner. It says Afroman with a symbol in the middle of it. If you look just to the side of that, it says October 4th, 2022 with a heart with 1.1K and messages is 71.
okay.
I cannot read that from you.
Next question. Go ahead.
We got the date on that one. Let's go to Exhibit 30, please.
I work daily, I get raid by Beto Bailey, Randy Walters, Private Pie. I used to fuck his wife, doggy style.
Do we know the platform on that one, Mr. Walters?
Is this the same video right here? It's still up because it's
Yes,
Instagram.
same one that's still up? Yes.
Instagram.
Instagram, and can you see a date?
September 25th, I believe, of 2022.
All right, thank you. And can we look at Exhibit 26?
That's why I feel just like they got to feel too rich.
All right. And I guess we should identify the platform for that one. Can you tell what platform that is?
I believe it's Facebook, August 26, 2023.
Thank you. All right. Did you become aware of these posts, Mr. Walters, at or about the time they were posted?
Yes.
How did you become aware of them?
Of my personal post, I found out from my children. When my daughter came home and advised me that she was getting messed with at school because apparently her mom is having sex with Afroman, and since she's biracial, that must be her daddy.
Oh, okay.
Along
Maybe
with
there was
the-
relevance.
And how did that affect you?
It's horrible. It's hard when your job that you're doing affects your family, which affects you. When you have a kid come home crying that's already been through a life, and now they're getting hazed and harassed because somebody thinks it's funny. Somebody knows it's not true. Been with my wife for 28 years. She didn't have an affair with Mr. Foreman. She didn't make my daughter with Mr. Foreman. But now my family has to be harmed because of straight up 100% lies. Where in the world is it okay to make something up for fun that's damaging to others when you know for sure it's an absolute lie?
First Amendment. Did you guys take those lyrics seriously about the doggy style? Because I did not take them for a second to be serious, one bit. So where do we do that? First Amendment. Yeah, and it's charity. Yeah, nobody took that literally.
Some of these posts that we've seen call you a thief.
Yes.
Did that affect you or your job in any way?
Yes. We as we've already heard, we can't go to calls, not figuratively every call, but the frequency of it, like people automatically, you're stealing Mr. Foreman's money. You illegally raided him. You've done all these things. You know, your wife's having sex with him. Is that why you stole his money? Never touched his money. It's been proven. He knows.
Did somebody say that to you?
Yes. You can't make these simple street arrests with people that are mouthy. I get that. But now there's just fuel to the rage. And then the fact that at the time I worked night shift, Adams County is a rural county. You do your work in your car a lot of the time. You do your paperwork in your car. Well, try to find someplace safe to sit when you're literally getting death threats because of lies. You're absolutely in fear for your safety to begin with as a police officer. But now intensify that because somebody is lying about a situation that they know the facts of. Now you have to worry about it because the calls, the comments, everything, all lying. It created a situation that was uncalled for, that was unsafe and unhealthy for the officers involved. The problem I have is the respect for my family wasn't near the respect.
This has gone to beyond a narrative. If
Overruled.
Mr. Foreman could ask a
Thank
question.
you. Responsive. Overruled.
Go ahead.
The respect for my family, including my law enforcement family, wasn't nothing like the respect I gave to his children the night of the raid. I stopped what I was doing when his wife, who I know and have been friendly with for years as far as being associates, said, hey, they were next door, somebody pulled in and they're scared. I stopped what I did, what I was doing, and went and checked on his kids to make sure they were safe, because that's a priority to me. But the same respect that was given to his family had no regard to mine or me. And that affects me. Because to see my family in distress because of my job is distressful to me. To have the public send you death threats over lies is distressing. And it was easy. Stop. Stop with the lies. But that wasn't enough. It's happening today. My kids came home yesterday because of new posts,
Your
same
Honor, I'm
thing.
going to renew this objection again.
Yes.
It's beyond the narrative at this point, and further, this is not bringing in evidence that is beyond this.
We're not going to allow like videos from yesterday. I get that. Last Friday, we have a video. I get what you're saying about the evolving nature of the conduct. That testimony is consistent with other people's experiences of the harm, but we're not going to bring in the exhibits. We're not going to bring in the content.
But they can testify about stuff that's happening at this time.
Yeah, it's the effect,
Oh.
I
not
would
the
register an
content.
objection for the record on
Got
that.
it. You're in. Next question.
Had you finished your answer?
Yes.
Any other ways you haven't mentioned that you want to share about how these accusations of a theft and your wife having sex with Mr. Foreman have affected you or your reputation?
It's affected all of our reputations, from a baseless lie till now, that we are not thieves. We didn't steal his money. I never touched his money. but I'm in the group of thieves. We stole his money. I spoke to him on the phone when he was concerned that he was going to be arrested that night. And apparently in some way on the phone, he didn't like my attitude towards not fixing his door. I'm sorry if you felt that I disrespected you in some way. I was explaining to him that we don't have the means to fix his door. We're leaving it in care of his wife. But I also cooled his fears that we're not coming to arrest you. Deputy or Sergeant Newland would like to talk to you. Get your attorney and come and talk to us. There's not going to be an arrest warrant for you. If we need to talk to you, we can find you. We can call you. You can come in. If an arrest warrant would occur, turn yourself in, go through the system, and do whatever. Nobody's chasing you through the woods, as reported. Nobody's doing any of that. The respect that was given to him, which I guess is not required in society, was not put forward to us.
You have different, you're a public officer.
Those are all my questions. Thank you.
Cross-examination.
He thinks he's so important and somehow sheltered from First Amendment protections.
For the record, you stated previously your name was Randy Walters.
Randolph Lee Walters Jr.
Okay.
I go
And
by
so
Randy.
you go by Randy.
Yes.
Do you mind if I call you
Yes,
Randy?
it's perfectly fine, sir.
So you extended Mr. Foreman a significant amount of respect that night.
I felt that I did.
Oh, here we go.
If I show you some
Here
of
we
the
go.
surveillance footage, can you explain how that is showing respect?
Sure.
Do you want to sample one?
What's the exhibit number?
This will be Exhibit F, Defense Exhibit F. This will be an excerpt of the security camera footage of Mr. Foreman for the kitchen of his home. From the time in question of August 21st, 2022.
Make sure we get the counter time, so we know what the Court of Appeals would know what the jury saw.
Pardon me, I'm
Make sure we get the counter time, so the Court of Appeals knows what the jury saw.
So I'll ask a couple questions while I wait for this down. So you took part in the search warrant execution.
Yes.
You were part of the breach team into Mr. Foreman's house.
Yes.
You had a riot shield-like thing?
No, a ballistic shield, sir.
Well, what's a ballistic shield?
It's a bulletproof shield. It's commonplace when doing raids that police officers get shot, and it's a safety device.
So it's a safety device shield about yay long with a little hole, a little
Yay.
window in it so you can carry it forward?
Yes.
So, do you see what has been marked Defense Exhibit F?
Yes, I see something on the screen.
Okay, so on that screen, does that appear to be the kitchen of Mr. Foreman's residence?
Yes.
And you would agree that that gentleman there with the firearm is Mr. Brian Newland?
Yes.
Okay. And so this would be the beginning after breaching the door?
From this, I can't tell what part of the entry it was.
Let me play some more. Okay, so this would be starting the security camera footage of 8/21/2022, starting at 8:13 and 4 seconds p.m. I've stopped it here because I'm going to ask a question. So you talked about a ballistic shield. Is that the ballistic shield you're referring to?
Yes.
And you would be behind that ballistic shield?
Yes.
So, putting this image in perspective, you're behind the riot shield.
Yes.
Officer Shawn Cooley's behind you. Brian Newland's in front of you. And Sean Grooms is going forward with the assault rifle.
Mm-hmm.
And you're flipping off the security camera.
No.
That's not your middle finger.
No, do you know how to use a ballistic shield, or do you like me to tell you?
Let's watch it.
The cake.
Finger went down, right?
There's a light activation on that shield. It's 35
The
pounds.
finger went down, correct?
If you think I was flipping him off, you can think that that's not what it was.
Okay.
Okay.
There's a light activation on the handle of the shield.
Mr. Walters?
Okay, go ahead.
Wait for the question. So, you were called a couple names by Mr. Foreman, one of those being, what was it, Beetle Bailey.
Yes, sir.
Does anyone believe you're Beetle Bailey?
Probably not. That's a drawn cartoon.
Beetle Bailey is a cartoon that's in the newspaper.
Sure.
Been there for years. So that would be an exaggeration. Okay. And when they call you a son of a bitch, that would be an opinion?
I'd say that would be an opinion.
Okay. Because there's no way we
Sir.
can prove whether you're a son of a bitch or not.
Nah, she's been dead for years.
I'm sorry. I am sorry about your mother on that. I am. But
Damn.
you would agree, though, that when someone calls someone a son of a bitch, it's not necessarily a statement of fact. It's more a statement of opinion or a description of a person.
Sure.
Okay. The same thing with being called, I think it's Gomer Pyle.
Yes.
No one would think you're Gomer Pyle from the movie?
Obviously, that's a character in a movie.
Yeah. But you're not that person.
No.
The chair squeak. Or the chair groan.
This may sound stupid, but you've been a law enforcement officer for a long time, correct?
Yes.
You've been called many derogatory names, correct?
Over the years, yes.
You've been called a son of a bitch before, correct?
Not published, but yes.
Okay. You've been called other things even worse, correct?
I'm sure over the years I've been called many things.
And it'd be fair to say that during those years, people probably said bad things about you and your family also.
You know, I honestly can't remember bad things being said to my family,
Okay.
but I can remember bad things being done to them.
Do you believe everything you read on the internet?
No.
Do you believe everything you read in the newspaper?
No.
You probably tell your kids, don't believe everything you hear, right?
Especially now.
So, are you testifying and claiming that because Mr. Foreman called you Gomer Pyle, you've been painted in a false light with the public? I'm taking it one at a time, so I'm going to get to
The
it.
Gomer Pyle?
Yes.
I'm not claiming that, sir.
You're not claiming that being called a son of a bitch is a claim you're pursuing, that Mr. Foreman's called you?
Correct, sir.
Being called Beetle Bailey, you're not claiming that is part of defamation proceeding on that, correct?
Correct.
Okay. And neither one of those three statements have painted you in a false light, correct?
Correct.
Okay.
Well, I mean, it depends. I mean, it paints you in a different light than what you are, but correct.
What?
So you're solely being painted in a false light due to Mr. Walters saying he had sex with your wife?
Mr. Walters does have sex with his wife. Mr. Foreman doesn't.
Good catch on that.
Yeah.
So you're claiming that is the defamation statement, is that he said he had sex with your wife?
Yes.
Okay. And that's painted you in a false light?
It's caused tremendous pain in my life.
I'll get to that. We have to go through false light first. So does it paint you in a false light?
Yes, that my wife is cheating on me with Mr. Foreman.
But we all know that's not true, correct?
I don't know.
What? So you don't know if it's not the truth? So now we have to call the wife.
Wait, you don't know if your wife's cheating on you or not?
You want to go there?
No, I just want to ask that question because you said we don't know. I just
Been
need
with
the
that
answer.
woman since middle school.
I know.
I would hope she wouldn't. But you know what? Once somebody puts it out there for their fun and entertainment, it's out there. And it's a problem.
So it's something we cannot verify the truth of?
Say it. Yes. He knows he can't say it.
Is it a thing that can be verified, true or false?
Ask your client.
Your Honor, I'm going to ask for a direct the witness to answer the question, yes or no, please.
You don't like his answer, doesn't mean he didn't answer.
He didn't answer the question. He's told me to ask another person. That is not an answer to the question.
Wow.
Another question.
Okay.
That was his answer. You didn't like how it came out, but it was his answer. We can't make him say something else. You can ask him another question.
And so are you claiming that Mr. Foreman saying he had sex with your wife is a private fact about your life?
My family is a private part of my life.
About your wife?
Him having an affair with my wife would definitely be a private part of my life if that was occurring.
And that has affected your reputation?
Yes.
Okay. And so, am I right in concluding that the other final statement that you are claiming that Mr. Foreman said about you that painted you in a false light is that you're a thief?
Yes.
Okay. And that stems
Whisper.
from all the posts that, and all the exhibits that Mr. Klingler referenced earlier?
That's what he showed.
The ones that talk about the police officers in general?
Yes.
Okay. Were you ever disciplined due to anything Mr. Foreman said?
No.
Ever passed up for promotion?
No.
This may be a stupid question. Were you a sergeant before or after the
Before.
search? Okay. Because I know you couldn't remember when, so I was just curious on that.
It was from before.
Okay. Have you ever talked to the People's Defender or Informer about the statements?
We were not allowed.
So you were not allowed by the sheriff of Adams County?
Yes.
Okay. And you had a cease and desist letter sent prior to January 1st of 2023?
I personally made no notification.
Okay.
Everything's been made through my attorney.
Okay. But that would be after January 1st, 2023, to your knowledge?
I'm not for sure the date.
If this lawsuit was filed after January 1st, 2023, you would agree then that it would have happened after that?
I don't know if they sent you guys a letter before or after they filed suit.
Okay.
I do not know that.
Okay. So that would be something I should ask another plaintiff?
Yeah, I didn't handle the paperwork. I don't know what date you got that, sir.
Okay. Do you agree that how you act during your job duties affects your reputation?
It does.
And I think I've asked this, but I'll ask again. The public has commented on your job duties in the past?
I'm sure they have.
They've been critical of you?
I'm sure they have.
So it didn't change your reputation. You don't know.
Did you order Lisa Phillips to disconnect the security camera?
I don't, and I haven't reviewed the body cam since that event. I know that the intent, if I can, for the camera system is, in speaking with Detective Newland, that they thought there was some type of operation of narcotics transfers there, so it would be obvious that if there's a surveillance system, that would be on it. That camera system was disconnected with my multi-tool by Sergeant Phillips. I will trust in the
Lisa,
fact,
look
because
up
I have not
Phillips.
reviewed it, that I said, hey, disconnect it. I don't know for sure that I did, but I know that she used the multi-tool to disconnect it, and it was placed in the central area in that room for evidence to be collected, because it was to be collected Because obviously, if you thought something was going on in the residence, you collect the surveillance system, you go later and get another search warrant.
So
I
we're
didn't
getting
find
into
out
the search.
until a couple days later that that was not actually collected.
It was left at the scene,
Yes,
but it was disconnected.
yes,
And you were
to
standing
take
there?
his evidence.
To take his evidence.
Yes,
But it was not taken as evidence.
it was not.
So the only thing taken as evidence, significant evidence, was the cash.
There was a jar of marijuana that was found in like the ball cap room, some cash, and some vapes, as I remember.
No one was arrested for threatening you, correct?
Not our choice, but no.
That was a choice made by the sheriff?
I can't tell you whose choice it was. I know that the agency as a whole was very upset and very concerned, and between the powers that be, whoever that is, there was no charges filed.
Okay.
This may sound stupid, but being a son of a bitch is not a crime, correct?
No.
You might have a second, Howard.
What fun to be able to ask these questions. Ask him about the wife one more time.
Your Honor, I have no further questions for this witness at this time.
Thank you, Mr. Osborne.
Thank you, Your Honor.
His face.
Mr. Walters, I'm only going to put the body cam up again. I was frankly a little confused about what it was supposed to show, but explain to me what it was that Mr. Osborne said he thought he saw that you were explaining.
May I stand up, sir?
Yeah.
A ballistic shield weighs about 35 pounds. Okay, it's very big. One hand has your firearm, or if you're using it for something. The other hand, there's a bar like this. To activate the lights that's on the front of it, there is an activation switch on that shield. That's what occurred.
So so your finger moved or something?
Yes, that's how you activate the shield. And it's also 35 pounds. Once you're carrying it for a while, it takes a toll.
So were you trying to flip the bird to his security camera or something? Or
No.
We're trying to make a disrespectful gesture in any way?
No.
You were asked a lot of questions by Mr. Osborne about things you might have been called before, criticisms you might have undergone before. Has anyone called you a thief before and published it?
No.
Has anyone ever published a statement that they fucked your wife?
No.
Have your kids come home upset because somebody said Afroman somebody else was their father at some point before this?
As recent as yesterday. Because everything is brought back up again.
Were you at Mr. Foreman's deposition?
I was not.
Okay. Those are all my questions. Thank you.
Recross?
I want to watch Afroman's deposition. 2 of them. There's 2.
Your Honor, I had no recross of Mr. Walters.
Sure, go ahead, step down.
Thank you, sir.
You have a witness coming at 1 o'clock, right?
We do, Judge.
Okay, so we have lunch break till about 1 o'clock. Enjoy yourself, don't talk about the case, don't research.
Don't
Keep
go
your
listen
breath,
to Lemon
don't
Pound
use
Cake.
Fresh air, stretch, don't deliberate thoroughly. Have a good lunch.
All right, we're going to read more motions.
Go on, Shirley. record again.
Yeah, don't dance in the lobby. All right, nothing interesting. So they're going to lunch for an hour. We're going to look at the docket.
I need the record just a moment.
Staying back here, duty, or coming out?
Thank you.
Try to be a gunner. Now, is there someone in the background, do you know?
I don't know.
There is. There's one more, Your Honor.
Thank you.
Yeah, someone's in the background.
Okay, this won't take long.
Well, I think they're coming
Oh,
out.
okay.
I heard the lock.
Also, big thank you here. Vague and Ambiguous became a green member. Thank you so much, and good to see you.
Okay, I'm sorry. No, you are fine. No problem.
Yeah, are we in someone's purse?
You're fine. Okay, sorry. We're ready.
Okay, so just two housekeeping items. One, Mr. Osborne is playing defendant exhibit F, played from 8/13/04 to 8/13/58.
I think that's correct, Your Honor.
So it looks like there was 54 seconds of time there. And then when we discussed that there's claims being dropped, the injunctive relief claim then counts.
All right, that's important. So one of the sidebars to approach, he was asking to dismiss at least one of the counts for one of the plaintiffs. It seems like maybe.
So it looks like there was 54 seconds of time there. And then when we discussed that there's claims being dropped, the injunctive relief claim in count 6 is still in play.
That's correct, Judge.
But that's a judicial decision.
Yes.
A judge decision, not a jury decision. So the jury doesn't get instructed, but the claim's still active. It's the claim for the judge to decide. So just to make it clear, when they dismissed one claim, previously counts 1 and 2 were dismissed by the court. I'm not sure who was assigned at the time. We started out with 3, 4, 5, and 6. 6 is for the judge to decide, that's injunctive relief. And then the plaintiffs dismissed the 4th claim. So if we're counting claims on the indictments, 3 and 5 go to the jury, and 6 is for the court. Right, Mr. Klingler?
Yes.
Makes sense, Mr. Osborne?
Somewhat, yes, Your Honor.
Okay, what doesn't?
That's probably a better argument at that time on what the injunctive relief could be granted in this.
Well, no, I get that, yeah, but it's not a jury issue. And it's
No,
not-
I agree with that.
And it's not a dismissed issue.
I don't know if it's a relevant issue, but I would agree it's not a jury issue.
Fair enough. Okay, we agree. This is a different way to say the same thing. We got it off the record. Have a good lunch.
Thank you, Judge.
Yep.
All right, so looks like they'll have a new feed starting in the hour. We're going to go over to the docket. We had left off, and guys, what they were just briefly saying there, they're making sure they had timestamps noted for the record of what part of the exhibit was actually played in court. And then that second issue, the way that the complaint was filed by the plaintiffs in this case, they made injunctive relief a count. And when the judge issued the order dismissing counts 1 and 2, which were like the use of the merchandise and profiting off the likeness, when he addressed count 6, he made a quick note in the order like, hey, this is like a relief. It's like a judicial matter, not a cause of action that should be proceeding to trial for like the jury to determine. So I don't really know what brought that up to make that relevant today necessarily. They probably, maybe they were just disagreeing over what numbers to talk about in front of the jury. And then these motions, we were reading, this is from March 16th. We were in the middle of reading this earlier in the stream during one of the earlier points of downtime. And it's the defense's response to the plaintiff's request to exclude certain things at trial, including the music videos. So we've gotten through that, and where we left off was, we're on like page 8, I think. The argument, this is the defense replying to the plaintiff's argument that body camera footage should be excluded because it's not relevant. So the defense response is that the body cam footage is relevant to the defense in multiple ways. It is an almost limitless source of impeachment evidence against all the plaintiffs who were deposed. Oh, I do think we read this part, but let's see. After all, while the counterclaims may not be at issue, the truthfulness of the plaintiffs will be, even more so now that the plaintiffs are claiming damages to their reputation. The defense shall present evidence that the plaintiffs were less than truthful during their depositions. The events they described and answers to specific questions were answered with outright fabrications that are not supported by their own body camera footage of the event in question. Yet this is not the only evidence that would come from the body cam footage. A similar argument can be made for the body cam footage that was made for the music videos or songs above. The plaintiff again failed to complete... Oh, this is where we were. We were on policies and procedures, I think. Maybe not. Yeah, I think we were... Yeah, that must be it. So similar as the Adams County Sheriff's Office policies and procedures, show the correct procedure for the execution of a search warrant and the handling of cache evidence. So the plaintiffs don't want the policies, the manual, to come in as an exhibit at trial. The plaintiff all but admits that Plaintiff Newland did not follow the policies and procedures in relation to the handling of cache evidence. The introduction of this evidence will show that Plaintiff Newland did not follow procedures when collecting cash at Mr. Foreman's residence. Newland was the first witness from day one. He's the one that did not seal the envelope. This information is relevant to Mr. Foreman's defense. Further, the failure to show the Adams County Sheriff's Office policies and procedures clearly show that the plaintiffs violated their own policies and procedures. That evidence is relevant to the defense of Mr. Foreman. The defendant is entitled to present evidence about all aspects of plaintiff's conduct during the search, not just the money seizure. Failure to allow this would improperly limit the truth defense of the defendant. Yet the plaintiff again fails to complete an analysis on why a limiting instruction is necessary, especially a limiting instruction that only favors the plaintiff, because they keep wanting to just, oh, it was lawful, the search was lawful. They want the judge to opine on that to the jury. Without an analysis, the plaintiff is fishing to determine what the defense will use their exhibit list for. Rather, a citation to Evidence Rule 105 is made. Rule 105 states that when evidence which is admissible as to one party, or for one purpose but not admissible as to another party or for another purpose is admitted, the court, upon request of a party, shall restrict the evidence to its proper scope and instruct the jury accordingly. And that's probably just citing the rule. Even reading Rule 105, the plaintiff is required to conduct an analysis so that the correct scope and instruction of the jury can be determined. None was completed by the plaintiff. So this brings us to the final section of the plaintiff's motion, the point where they go completely off the rails. The plaintiff makes two arguments in relation to why the witness Rhonda Grooms, Natasha Purdon, Carly Patterson, these are all spouses. These are all spouses of people. So we heard a line of questioning about, is your wife effing Afroman? So you see why some of this might be relevant? Like, very, very fun trial we have here. We have a footnote by Carly. So Ms. Patterson is not contained in the latest amended witness list of the defendants and thus will not be discussed. So they're withdrawing. They don't want to call Carly Patterson. Dorothy Chandler, Tabitha Spires, should be excluded and prevented from testifying. That's what the plaintiffs want. The first argument is that they have no evidence relevant to either the defendant's dismissed counterclaims or the claims of the plaintiffs. The second argument is that they were not disclosed during discovery. To counter these assertions, they must be taken one at a time. The first is if they have relevant evidence. The plaintiff seeks to exclude a number of witnesses listed by the defense due to the fact that they are either current or former romantic partners of some of the plaintiffs, to wit, Brian Newland and Shawn Grooms. The plaintiff, without any analysis, just asserts these witnesses have no evidence that could be relevant. The former, I believe there's videos with statements from some of these witnesses, and I don't know the names of, like, I can't match face to name quite yet. But if you go and watch Afroman's channel, especially videos that he's published this weekend, there's clips from some of these individuals speaking and saying things that are not great about Brian Newland and Shawn Grooms. And if these individuals are the source of the information, it goes to the truth of what Afroman might be saying or why he holds a certain opinion or view of these individuals that are suing him for defamation. So they continue here that the plaintiff, without any analysis, just asserts these witnesses have no evidence that could be relevant. Just because they have no relevance to the plaintiff, or the plaintiff cannot understand why a witness would be called, does not mean that the witness does not have any relevant information. These witnesses may have relevant testimony regarding damages, including plaintiff's alleged reputational harm and impeachment evidence. In defamation cases, damages are a critical element, and witnesses with knowledge of plaintiff's reputation are potentially relevant. This does not mean that they will be called. Rather, they could be called to mitigate or otherwise comment on elements of the plaintiff's case. Just because the plaintiff does not know what they will testify to does not make them irrelevant witnesses. The plaintiff raises a second clumsy claim as a Hail Mary, attempting to knock out the defendant's witnesses, that he did not know of them and they were not disclosed by the defendant during discovery. What is the plaintiff attempting by this statement? It is unclear if the plaintiff is asserting a discovery violation or stating something they believe is fact. However, for the sake of confusion, it will be analyzed as an assertion of a discovery violation. Yet even treating the statement as such will not relieve the plaintiffs of their burden. The plaintiffs assert that discovery is a perfect process. It is not. It's a messy process by which a significant amount of evidence is requested and sorted. Each side looks at the evidence differently and builds their case and defense based on their views of the evidence. However, mistakes occur. However, it should be noted that the plaintiffs have only made a very general assertion without any reference to how a violation occurred or how courts have viewed situations such as these before. Before the analysis of the defense begins, some background is necessary. The witnesses, Rhonda Grooms, Dorothy Chandler, and Tabitha Spires, were discussed in the depositions of Plaintiff Shawn Grooms and Plaintiff Brian Newland, respectively. This is when they were brought to the attention of the defendant. They were not names picked out of thin air. The witness, Natasha Purdon, was only brought to the attention of the defense when interviewing Rhonda Grooms and observing that Natasha? Maybe it's Natasha, not Natasha. Natasha. And that Natasha and Plaintiff Shawn Grooms entered a relationship the day of his deposition on Facebook. What? Plaintiff Shawn Grooms cannot complain of surprise that the person who he sees every day could be a witness. These witnesses were known to the plaintiff since the time of their deposition in August of 2025, thus they are not a surprise. Further, the issue of these witnesses was mentioned by the defense at the telephone status hearing prior to the trial. So they mentioned it, that was like February 26th, I think. The plaintiff's attorney said that he might have issue, but did not know if he would file anything. The surprise to the plaintiffs is that they do not know what they will testify to. The defense asserts that no discovery violation has occurred. Yet, should anyone disagree, an analysis of the relevant case law will settle the matter once and for all. He's like, anyway, this is David Osborne. This is Afroman's attorney writing this. Ohio Supreme Court held that a trial court must inquire into the circumstances surrounding a discovery rule violation and, when deciding whether to impose a sanction, must impose the least severe sanction that is consistent with the purpose of the rules of discovery. Applies equally to discovery violations committed by the state and to discovery violations committed by a criminal defendant. The Supreme Court went further to state that they believe that the equal and reciprocal treatment of parties is important when looking at discovery violations. Also, that considering sanctions, the court shall investigate and impose the least severe sanction that will further purposes of the discovery rules is a critical consideration that must be taken into account in any case before a severe sanction is imposed for a discovery violation. The Supreme Court emphasized that three factors that should be given a trial court's exercise of discretion in imposing a sanction for discovery violation. These are whether the failure to disclose was a willful violation, whether foreknowledge of the undisclosed material would have benefited the accused in the preparation of a defense, and whether the accused was prejudiced. So this is all in the criminal context still. This is the standard the plaintiff must follow the analysis before making an assertion of a discovery violation and demanding exclusion. In the case at hand, the plaintiff has totally failed to correctly raise or even articulate how the exclusion of the defendant's witness is warranted. The plaintiff cannot just assert a discovery violation and seek exclusion. They must articulate how the exclusion is necessary under the three-pronged test as articulated by the Ohio Supreme Court. Plaintiff has failed to show, or even allege, that the failure to name these witnesses is a willful violation, a fact that is necessary to even start the analysis. The plaintiff has not articulated how having the names of these witnesses earlier would benefit them in the preparation of their case. Most importantly, the plaintiffs have not even alleged how they were prejudiced, let alone articulated how they'd be prejudiced. Even if all the prongs were met by the plaintiff, they failed to articulate how exclusion is the correct remedy that is the least restrictive. Thus, the desire of the plaintiff to have witnesses excluded must fail as a matter of law. The plaintiff's motion in limine fails completely. The plaintiff asserts that the defense intends to defend this case with the relevant and sensational exhibits that attack and belittle the plaintiff deputy sheriffs. And the plaintiffs are the ones that played the Lisa video, the Lick 'em Low Lisa video. The plaintiff then goes on to make rather clumsy and bold assertions about the defense and its evidence. No analysis is provided, and nothing more than a few cites to the rules of evidence are made. The person bringing the motion bears the burden of proving their position through presentation of the relevant law and analysis. The plaintiff fails to do that, and thus the motion must be denied. So therefore, Afroman respectfully requests this court deny the motions in limine by the plaintiffs, and for such other relief as deemed just and proper. Law offices of Dr. David Osborne, Jr. There for Afroman. So that was the motion we left off on. There are more, you guys. There are more. We're gonna go down. We're gonna catch up on this docket during the lunch break. What are you guys saying here? Let me give a proper thank you here. We had Becca become green. Thank you so much, Becca. Looks like Becca from Texas. Thank you so much. We have Auntie M gifting 5 gifted memberships. Thank you so much for that. And also over on X, thank you for, talking about these motions. I saw, it looks like Megan Fox, the writer, and that umbrella guy are going to take a look at this case later this evening. So that should be hilarious. You guys might remember them from Dep v. Heard commentary. I think they've also done a lot on the What the Hales saga. And a few other cases that sort of deal, even if it's not really the central issue or the issue that started something, it all seems to circle back to First Amendment issues, the topics that they cover. So that should be a good one. I know I'm Not a Lawyer, but is obviously covering this and doing daily recaps as well. I think Thursday, Justice Serve TV will be doing a recap, again, a First Amendment analysis, taking a look at what's going on in this case. I'm sure Nick Starr is going to go live and talk about this as well. So plenty of people here wondering, why are we here? Why are we here? So thank you, Auntie M over on X for, talking about this case. I think it's a good one to follow. It's entertaining, sure, but it's really a bunch of cops who got mad that somebody commented about their raid, and now they're suing. And I don't think that's I don't love that. I don't love that, and I hope that the jury sees an issue with that. Prince of Wales, also shout out to Broken Baker. You guys rated here. Shout out to Broken Baker. I don't know if he's going to be covering this trial specifically, but he's always covering different trials. Lots of crazy cases over there too. He's probably one of the funniest to watch for the Wolfenbarger trial out of Fulton County, Georgia. Crazy that the case was brought in the way it was brought, but the subject matter of that trial is top of my list of fun trials to watch. It's a cold case murder trial where the victim's family members, the dad was known as the Flint River Killer. So you have third-party culprits who are killers. So, great time over there. So love Broken Baker. Good to see you guys. We've got Prince of Wales saying, do you read super chats here? If so, I will take my millions away from Baker and begin funding this channel. Well, thank you. Don't take it away from Baker. We got to keep him going. I appreciate the support, though. I'm hidden back here. So thank you, but never an if and or, and never feel obligated to send in a super chat over here. You know, I always wanted YouTube to be a hobby. It's kind of becoming full-time. So kind of in a weird mix where I can't say that I don't need some income revenue to support what I'm doing, but it's really never, don't ever give what you don't have, and just know that anything's always appreciated. And then we have Prince of Wales saying, everyone congratulate Sue on her pregnancy. It's her second trimester. She gets a bit grumpy, but it's a miracle at her age. You got to fill me in on the context here. Yeah, and everyone, nobody knows why Wolfenbarger was in a wheelchair. That's the question that plagues me from that trial. So guys, what are your reactions to these motions in limine? So, let's see. Let me scroll up a bit from when we were reading. Let's see. Fly Cash says, can you imagine if he wins this case, what song he'll make next? I mean, I don't know if he'll even wait until the case is over. Because right now there's a request for an injunction, but there is no injunction in place. So, yeah, Steven says he hired himself a good lawyer, which he's entitled to. I'm really enjoying Osborne. I think he has the right, I think he's a good lawyer. You know, that I'm just saying that in a bubble based on his advocacy. But I also think he has, like, the right delivery. I don't know really how to, what vocabulary word would be the correct description here. The gusto? But he just seems like the right attorney for a First Amendment issue. And he's not going to get up there and quiver because there's crass words being said. Right? He's going to be like this. He's going to get up there and he's going to demonstrate. It's just ridiculous. So you're basically here, you're suing because you were called a dipshit. And he'll just say it plain out. And I think that's the correct delivery for what he has to argue here in this case. If anyone missed it, anybody missed that little, it was in the previous motion that we looked at this at the beginning of this. Oh, why an error? I had it on X. Let me just find it on X and show you this clip. At the beginning of the stream, we looked at the motion in limine to exclude the testimony and report of Michael Robinson, someone from a neighboring sheriff's office that did the independent investigation about whether or not $400 was stolen or if it was just a miscount or mislabeling of this envelope. And in that motion, which was written by Attorney Osborne, he's kind of trolling and doing this like Law 101, like explaining basic procedures. And eventually at one point we get this nice little buzz line. After all, Mr. Osborne is not the brightest attorney, maybe nothing more than a hillbilly hick. Yet it seems that the plaintiffs are finally understanding why Mr. Osborne was hired. And I thought this was just such a great line. Let me see. It's going to make me log back in. Guys, if you want to look at anything from this docket, I linked to the website in the description, but you still have to do the search once you get there. It's adamscountycourts.com. And with a lot of, case lookups, if you search Joseph Foreman, you will not find it. If you search Afroman, you will not find it. If you search man, Afro, you will not find it, as Mavka tried to do. You've got to do it by whatever format they request, and typically they want the last name, comma, space, and then the first name. Sometimes the middle, but I usually just leave it out. And if you don't do it like that, you won't get the results. And then you want to come down to the civil case down here, and you can get to the docket. So, yeah, most of the stuff is available. No purchasing of documents for this case, which is awesome. And we would be here. The next one we're going to read, also from yesterday, is Defendant Joseph Edgar Foreman's memorandum in opposition to plaintiff's motion in limine to exclude, wrong one, this one. Memorandum in opposition to plaintiff's supplemental motion in limine. When was there supplemental? if we read the supplemental. Let me see. Okay, so it was also filed yesterday. Let's start with this, and then we'll go down. All right, so we've got, let's see. Prince of Wales, thank you. Well, I appreciate I appreciate the commentary, and I'll be the recipient of your support via narcissism. Prince of Wales says, with a super, I never feel obligated. I'm just a narcissist who likes my cameras red. Well, that works for me, so thank you. Thank you indirectly for feeding your narcissism. We've got here, plaintiffs submit this supplemental motion in limine asking for an order prohibiting defendant and his counsel from presenting testimony, making statements, and questioning witnesses about topics that are highly prejudicial, inflammatory, and irrelevant to the issues being tried. Is this a motion in limine to not be able to ask a client if you really think that Afroman is banging your wife? This is filed by Robert Klingler. Let's read it. In recent days leading up to trial, defendant Joseph Foreman has ramped up his efforts to defame and humiliate plaintiffs. He is engaged in a massive pretrial publicity tour and posted additional defamatory materials about plaintiffs on the internet. Unfortunately, and most disturbingly, he's been aided in these efforts by his trial attorney. On Friday, March 13th, 2026, Mr. Foreman posted a sexually explicit pornographic music video to his YouTube channel titled Lick 'em Lolisa, which the plaintiffs played in its entirety in court yesterday. A link to this video has been sent separately to the court to avoid its unnecessary publication in court documents. You published it to the jury in court! What is this? Oh my gosh, I needed to be quicker on the trigger with this one because this was the perfect opportunity for this. I think it's funnier that we're reading this late. Plaintiffs will supplement their exhibit list to include this posting. Mr. Foreman included excerpts of Plaintiff Lieutenant Phillips, that's Lisa Phillips, video recorded deposition testimony in this music video. He hired an actor to portray Miss Phillips and filmed scenes of this actor pretending to be Miss Phillips during her deposition in Mr. Osborne's office, where the actual deposition took place. He intersperses scenes from the actual deposition with the scenes of the actor. So that's why they're saying the attorney was with it, because the scene of the video is using the law office where the depositions were taken. The actor is portrayed, the video, as having sex with a variety of women and with Mr. Foreman. The content of this video is shocking to the conscience of ordinary people. It's also apparently meant to be comical. And a reenactment. Mr. Foreman has made other defamatory posts about numerous plaintiffs on the eve of trial. In one, he references the court's request for a record of settlement discussions and further defames plaintiffs. In addition, Mr. Foreman has called for his supporters to gather at the courthouse in support of him Monday morning at the trial. These videos appear to be intended to influence prospective jurors and to inflict maximum emotional pain on the plaintiffs. This is so stupid, though, because the plaintiffs keep trying to introduce these social posts, and they're like, look at how far it was disseminated, because they want to make the argument of publication, right? They want to make the argument that this stuff that Mr. Foreman's doing, and not stuff that's already damaged the reputation previously from unrelated matters in the community, is being republished and reaching a whole new audience. But at the same time, they're showing how many people are liking what Mr. Foreman's posting. They're showing clips, some of the video clips are like Afroman's performing, and you see an audience of people cheering him on. So they're allowing in visuals of support through what they're trying to bring in as exhibits. They're not asking to redact like the like count or whatever. So, but yeah. So they say he's trying to influence the jury pool. It is clear that defendant intends to turn the trial into a carnival of disrespect for the plaintiffs. You played the Lick 'em Low video, the court, and the judicial process. Plaintiffs are concerned that defendant will repeatedly attempt to inject irrelevant, highly prejudicial, inflammatory material into the trial, raising the specter of a tainted jury and the potential of a mistrial. Because of these concerns, plaintiffs move the court for an order requiring that defendant and counsel disclose, with specificity, any potentially prejudicial or inflammatory questions, evidence, or statements before they are presented to the jury, and that the court instruct all counsel and parties that disrespectful, disruptive, and intentionally inflammatory and highly prejudicial statement or conduct will not be tolerated. So, yeah. Like, what are we doing? What are we doing? Yeah, Streisand effect. Just crazy. Anyway, let's read the response to that one, because this is all, it's just however all of this spilled in and got put on the docket yesterday, but it's not necessarily the filing order. Let's see. All right, supplemental. All right, defense response to that supplemental motion in limine. All right, so it comes now. Joseph Foreman requests that the supplemental motion in limine be struck and denied. This case is progressed, blah, 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 blah. On March 13th, plaintiff filed a supplemental motion in limine in which they're seeking an order from the court to prohibit the defendant and or his counsel from presenting testimony, making statements, and questioning witnesses about topics that are highly prejudicial, inflammatory, and irrelevant to the issues. A copy of the plaintiff's supplemental motion in limine has been attached here too as Exhibit A. Further, the plaintiffs seek to have the court order that the defendant and his counsel disclose, with specificity, any potential prejudicial or inflammatory questions, evidence, or statements before presented to the jury. Footnote there just cites to the exhibit. This motion must be denied as it fails on multiple grounds. So if we read Rule 7 from Ohio Rules of Civil Procedure, an application to the court for an order shall be by motion, which, unless made during a hearing or trial, shall be made in writing. A motion, whether written or oral, shall state with particularity the grounds, which is italicized, therefore, and shall set forth the relief or order sought. And that emphasis was added by Osborne. Under Rule 7, a party must make a motion before trial in writing and detail out with particularity the specific evidence or testimony sought to be excluded. This is something that the current supplemental motion in limine fails to do. Which is why it's important they're noting that this was actually really filed on the 13th, even though it isn't on the online docket until the 16th, because that's before trial started. In the plaintiff's filing, they do not specify what they're seeking to exclude. Rather, they make a sweeping statement seeking to exclude the defense from presenting testimony, making statements, and questioning witnesses about topics that are highly prejudicial, inflammatory, and irrelevant to the issues. There is no specificity in the plaintiff's motion. After all, the plaintiff does not even detail what would be considered presenting testimony, making statements, and questioning witnesses about topics that are highly prejudicial, inflammatory, and irrelevant to the issues. Without examples, the question of what is highly prejudicial, inflammatory, or irrelevant is subjective and vague. This is supported by the fact that each side will have differing opinions on what falls into each of those categories. So if we can disagree on something, it's subjective. Rather than putting the defense on notice, these vague terms constitute a fishing expedition by the plaintiff to see what is going to be presented as a defense. Thus, the supplemental motion in limine fails as a matter of law and should be denied. The motion should also be denied because the plaintiffs are confusing trial evidence with out-of-court statements. The plaintiff goes to great lengths to describe how the defendant is making out-of-court statements and then postulates that these same things may be presented at trial. The plaintiff seeks to put an order on the defendant when the plaintiffs themselves have noticed the court and the defendant that they intend to present the same evidence they're claiming is an issue. The Lick 'em Low video. Thus, by seeking to introduce the evidence the plaintiffs themselves are opening the door to, the statements contained therein while attempting to silence the defense. However, the defendant has also served a motion in limine to exclude any statements, posts, or music videos made after April of 2025 due to changes in the law. So this is the new anti-slap statute that was enacted. If you want to go into the description, it's Trenton, who is not watching. I don't know if Trenton's watching live with us today, but you'll see him in the chat at times. He shared the link to the law that was enacted, as well as the Ohio Supreme Court looking at its application in another case where they're holding that its application needs to be retroactive. And what that means is you need to undergo the three-prong analysis that's required under what the 2025 law requires. So And based on the objections from the defense attorney yesterday, it seems like this court wasn't even willing to do the analysis to apply the new anti-SLAPP, Ohio State anti-SLAPP law. So they're preserving this objection. It's the kind of thing that I'm not a lawyer, but I would imagine Court of Appeals is like, yeah, I'd love to weigh in on that. Bring it up here. So with the confusion of pretrial statements and the presentation of evidence, the plaintiffs seem to fundamentally confuse two distinct legal issues: pretrial publicity and its potential impact on jury selection, and the admissibility of specific evidence during trial. The issue of pretrial publicity and its potential impact on jury selection has been addressed by Ohio courts before. So even though they improperly said what their issue was, I'm going to address it anyway. In the case of State v. Joseph, the 2nd District Court of Appeals stated that even pervasive adverse publicity does not inevitably lead to an unfair trial. The issue of pretrial concern is addressed by a separate mechanism, voir dire. The Ohio Supreme Court has long held that voir dire examination provides the best test as to whether adverse publicity necessitates a change of venue. A careful and searching voir dire provides the best test of whether prejudicial pretrial publicity, geez, that's alliterative, has prevented a party. How many P words are in this? Prejudicial pretrial publicity prevented a party from obtaining a fair and impartial jury from the locality. If the record on voir dire establishes that prospective jurors have been exposed to pretrial publicity, but would nevertheless determine the case solely on the law and evidence presented at trial, it is not error for the trial court to impanel such jurors. The remedy for the plaintiffs, if they have concerns with the pretrial statements to the press and posts, is an enhanced voir dire, not to limit what the defense can present, nor to have the defense present its entire case for review and approval by the court and the plaintiffs. Huh, that is spicy. He's grouping them together. The remedy is not to have the defense present its entire case for the review and approval of the court and the plaintiffs. Thus, the plaintiff's supplemental motion in limine should be denied. Even more troubling is that the plaintiffs appear to be filing their supplemental motion in limine to curb the freedom of speech that the defendant has to comment on his pending litigation. That's what this is like a free speech within free speech issue. Has to comment on his pending litigation, create artistic work, and engage in public discourse. This is a dangerous and troubling stance of the plaintiffs as Ohio law has changed since the lawsuit was filed. In April of 2025, the Ohio Uniform Public Expression Protection Act. So if you see an acronym like UPEPA, UPEPA, that's what this is referring to. It's Ohio's version of anti-SLAPP, which was part of the 2023 Ohio Senate Bill 237, went into effect. This was memorialized in the Ohio Rules 2747, which established a judicial process that did not exist before that allows for the early dismissal of strategic lawsuits against public participation, SLAPP. This new law expressly covers comments an issue. I think might be at issue, comments at issue under consideration or review in a judicial or other governmental proceeding. Thus, the plaintiff is asking for this court to punish the defendant for his actions outside of court by requesting the extraordinary, in order to have the defendant and his counsel disclose, with specificity, any potential prejudicial or inflammatory questions, evidence, or statements before asked of a witness. A remedy that defense counsel could not find a single case on point about, nor did the plaintiff cite any case in support of their position. The plaintiff also fails to acknowledge the truth of trial. You do not know what a person is going to testify to until they are on the stand. Attorneys may prepare and have witnesses ready to testify, only to ask a question or things to change during the trial. All attorneys are flexible and must adapt to changes as the testimony and evidence unfolds. After all, a witness may state something not covered in depositions, and the attorney will want to pursue that line of questioning. To have grant the request of the plaintiff would require the defense to try the case twice, once in advance to the plaintiff's approval and a second time to the jury. These concerns are entirely speculative. Plaintiffs provide no evidence that defendant intends to introduce inadmissible evidence or engage in improper conduct during trial. The proper procedure is to address objections to specific evidence or conduct as they arise during trial. If defendant attempts to introduce irrelevant or unduly prejudicial evidence, Plaintiffs may object at that time, and the court can rule on the specific proffer. This case-by-case approach protects both parties' rights while allowing the court to make informed evidentiary rulings. Thus, the supplemental motion in limine must be denied. Wherefore, the defendant respectfully requests that this court deny the supplemental motion in limine and for other such relief. So, and I know we've had objections. I know we're only on day 2, but I don't really think there's been objections that would demonstrate, like, hey, defense keeps trying to do all these things they're not supposed to be doing. So, it's not that this is even bore out, right? We haven't seen it bear out that the defense is trying to do these things that the plaintiffs were preemptively trying to prohibit them doing. So, yeah, it's not say, it's hearsay. So, there we go. Yeah, Finnegoop, 2 Fridays ago. I think it was 2 Fridays ago. I don't know if Tina's in the chat, but Tina had left a comment in the chat like, are you going to do the Afroman trial? And I was like, that thing's trial? And so it's been a rabbit hole ever since, because I remember like the big fuss back in 2023. It was just shocking to hear that it continued and was going to go to trial. So then we did the deep dive, and it seemed all the more ridiculous that it's going to trial, if you ask me. So glad you're here. I think a lot of people are in the same boat. Like, oh my gosh, I got to go see what's going on with this. So let's see. What do we got next? All right, so we kind of we did this first one. Take a look at plaintiff's exhibit list. They amended it. Let's see. Anything interesting? All right, a bunch of social media posts. We went through all the Lisa stuff. Randy. All right, so I think these were newly added. I don't know when 31 was added, but these are new. So they must have amended to at least add these 3 things. And I believe we've seen these 2. We haven't seen this come in yet with Mr. Grooms. But I don't know what this Facebook post is, but we did see the YouTube video regarding Lisa Phillips. So some of these new exhibits are coming in. Let's see. We heard that there would be, the defense was like, hey, we're going to correct the service dates because it was important in relation to this motion on Detective Michael Robinson, who was late disclosure. They didn't give the report over until a few days before trial. Let's see. Motion in limine in relation to any evidence sought to be presented that would have occurred or have been posted after the effective dates. This is the anti-slap one. All right. So cool. This should actually take us cleanly up. This is 10 pages. This will take us cleanly up to the end of the lunch break. Before we do that, Christy in the chat had found this post from 2022. Hold on, let me do this in another way. Let me take a screenshot, because someone shared the search warrant, and even though I think they've said Afroman's address, I want to scribble that out. Scribble, scribble. All right, so let me save that and bring it up with it scribbled. Okay. Well, let me easily share it. Don't be difficult. Ah, this is so stupid. Okay, there we go. All right, so any law enforcement officer of Adams County, Ohio, and this was what, August 23rd, 2022. Whereas there has been filed before me an affidavit demonstrating probable cause for a search to be made of, and it's the residence. I don't have the affidavit. I could try to look a little bit harder to find it, because I think that would be very interesting to see. It'd be more informative to see what they represented to the court. Defense seems to believe that there were misrepresentations in that affidavit. So I'd like to be able to see that. Although I do think we will hear more about it when other witnesses are called further down, maybe in the defendant's case in chief. So, single family, 2-story home with white siding, having green shutters and a green metal roof, with a covered front porch and a gravel driveway, having a large white metal pole barn style structure, with a green metal roof on the north side of the primary residence, with a wooden fence surrounding the property, and being the current residence of Joseph Foreman, to include any and all other outbuildings, storage containers, curtilage, vehicles, and or persons located on the property. Yeah, so somebody shows up. That's part of your search warrant now. You weren't going out there because you want to be so respectful and check on the safety of the people outside. You thought that was more for you to search. So we've got, namely, what are they looking for? Items of evidence, including but not limited to unknown quantities of marijuana, marijuana derivatives, any and all other drugs of abuse, drug paraphernalia, including scales, packaging materials, and paraphernalia used for the sale and administration of said drugs, money obtained. There's a comma between that. It says money, comma, obtained from the sale of illegal drugs. Documentation regarding the sale of illegal drugs, as well as weapons used for the protection of the above, which are being concealed in violation of ORC 292511, possession of drugs, trafficking in drugs, and kidnapping. You're hereby commanded to search by any reasonable means necessary the above named person and or place for the property described, serving this warrant and making the search during the daytime or nighttime within 3 days from the issuance of this order, and if the property be found, there to seize it, leaving a copy of this warrant and a receipt for the property taken, and prepare written inventory, maybe with the correct numbers, a written inventory with the correct numbers, of the property seized, and return this warrant to the Adams County Court of Adams County, Ohio, upon execution. Furthermore, this search warrant may be executed without the statutory precondition for a non-consensual entry. So that's why we got the no knock. This is Judge Goberth. I think they're going to say his name at some point, and we've said his name. I think his name was mentioned in some of the stuff we've looked at previously, but I cannot read that handwriting. This was signed off on the 21st of August, and up here it was returned on the 23rd of August to the court. So there's that. There's that. We've got... Is this where we are? Defendant's motion in limine? I think if we can get through this, this will catch us up. This will catch us up before they come back from lunch. So, yeah, the Lemon Pound Cake song is awesome. Very, very catchy. Because it's that Boardwalk song. So I don't know if it'll come in at trial, but his new one that's to the tune of the Glory Hallelujah song, that's a catchy one too. That was stuck in my head. So... Defendant Joseph Edgar Foreman's motion in limine in relation to any evidence sought to be presented that would have occurred or been posted after the effective date of the Ohio Uniform Public Expression Protection Act. So it's like UEPA, anti-SLAPP, whatever you want to call it. Comes now, Afroman, by and through his counsel, requests a motion in limine to prevent the introduction of any evidence against the defendants for statements and music made after the effective date for this anti-SLAPP law. This went into effect in early 2025. Let's see. Thus, the inclusion of any statements and or music made by the defendant after early 2025 would be subject to all the protections found within the anti-SLAPP law. We're going to say the act. We're going to shorten it. And the associated procedures such as expedited hearings and rights to appeal, none of which has been addressed by the plaintiff. For that reason and more set forth in the attached memorandum, the defendant asks for an order preventing any introduction or reference to any music or statements of the defendants after early 2025. A memorandum is in attached here too. So this is the heart of the argument. So since this case was filed, because this was filed in 2023, the Ohio General Assembly has passed an anti-SLAPP law known as the Ohio Uniform Public Expression Protection Act, which was part of the 2023 Ohio Senate Bill 237. This was memorialized in ORC 2747, which established a judicial process that did not exist before, that allows for the early dismissal of strategic lawsuits against public participation. Section 2747 of the Ohio Revised Code went into effect on April 9, 2025. Before ORC 2747 went into effect, there was no specific procedure to protect defendants in cases involving their freedom of speech and artistic expression. This was even more true for cases involving public officials, where significant issues of freedom of speech and artistic expression are at issue. Section 2747(01)B sets forth the matters that the section applies to wit. So Section B, and it's an ellipses, and then this chapter applies to a cause of action asserted in a civil action against a person based on any of the following. 1. The person's communication in a legislative, executive, judicial, administrative, or other governmental proceeding. 2. The person's, this is italicized here, the person's communication on an issue under consideration or review in the legislative, executive, judicial, and judicial's italicized, administrative, or other governmental proceeding. 3, also italicized, the person's exercise of the right of freedom of speech and of the press, the right to assemble and petition, and the right of association guaranteed by the United States Constitution or the Ohio Constitution, emphasized on a matter of public concern. Thus, when a defendant is sued in a civil action involving a person who comments on an issue under consideration or review in a judicial proceeding, or that person's exercise of his or her freedom of speech and or press, Section 2747, provides new judicial mechanisms by which he may respond to the civil action. In fact, the Ohio legislature went so far as to enshrine the purpose of Section 2747. And that's important because sometimes, if it's vague, higher courts can be asked to determine, well, what was the intent behind this? But here, the defense attorney is pointing out, they made their intent of what they want this legislation to do very clear. So they went so far as to enshrine the purpose of Section 2747. Section 2747(01)E states that the General Assembly, in enacting this chapter, intends to confer substantive immunity from suit and not merely immunity from liability. So before it even gets to the trial, it's not a question of should there be damages and liability found, but can it even get to the litigation? Can the litigation survive? For any cause of action described in Division B of this section, and that's just citing to the same code, the statute does provide some exceptions to Section 2747. In Section 2747(01)C, Ohio lawmakers limited the application of this new law in the following way, to wit. This chapter does not apply to any of the following. 1, a legal action against a governmental unit or an employee or agent of the governmental unit who is acting or purporting to act in an official capacity. 2, an enforcement action that is brought in the name of a governmental unit to protect against an imminent threat to public health or safety. 3, a legal action brought against a person primarily engaged in the business of selling or leasing goods or services, if the cause of action arises out of communication related to the person's sale or lease of the goods or services. And 4, a survivorship claim or a legal action seeking recovery for bodily injury or wrongful death, or statements made regarding the claim or legal action. When looking at the exceptions, the only one that might apply is found in number 3, a person primarily engaged in the business of selling or leasing goods or services. Now, those related counts were dismissed. The plaintiffs may attempt to argue that Mr. Foreman is not covered by Section 2747 because he is a person primarily engaged in the business of selling goods or services. Yet this would be an error, as the Ohio General Assembly addressed this by defining what goods and services were under Section 2747. In Section 2747, goods and services are defined as not include the creation, dissemination, exhibition, or advertisement, or similar promotion of a dramatic, literary, musical, political, journalistic, or artistic work. Yeah, I mean, I can see why Osborne is writing out this analysis. It seems very favorable to his argument, and it seems like it's something that totally devoid if you look anywhere else in this case. The plaintiffs aren't talking about it, and it seems like the judge hasn't wanted to weigh in. So they say, thus, any argument that Mr. Foreman would be in the business of selling or leasing goods or services fails, as musical, political, journalistic, and artistic work is not goods or services. Further, there is no issue that the posts at issue and the music videos at issue would involve Mr. Foreman's freedom of speech and artistic expression, and thus are covered by the Ohio Uniform Public Expressions Protection Act. The evidence that can be admitted at trial is governed by the Ohio Rules of Evidence. Under the Rules of Evidence, Rule 403, the court is permitted to exclude relevant evidence on grounds of prejudice, confusion, or undue delay. Rule 403 states that the exclusion of evidence is mandatory when, to wit, although relevant evidence is not admissible if its probative value is substantially outweighed by the danger of unfair prejudice, of confusion of the issues, or of misleading the jury. The Honorable 4th District Court of Appeals has stated that exclusion based upon confusion usually is justified where the offered evidence would require the trier of fact to engage in intricate, extraordinary, or impossible mental gymnastics in order to comprehend the import of the evidence or to assess its weight. Thus, even relevant evidence must be excluded if it will mislead the jury or confuse the issues. On March 13, 2026, the plaintiffs served their plaintiff's second amended list of exhibits. A copy of the filing has been attached here to Exhibit A. In the new list of exhibits, the plaintiff notes several posts and music videos that were made after April of 2025. These are identified as exhibits numbers 2, 3, through 33, 34, 35, and all have dates ranging from March 2nd, 2026 through, so this month, through March 13th, 2026, well after April 2025. Thus, they would be subject to the provisions and protection of Section 2747 of the Ohio Revised Code. We've got, if these are permitted to be introduced, then the defendant will be denied all the rights granted by 2747 of the Ohio Revised Code, and further allow the plaintiffs an outrageous advantage of not having to address the changes in law which would govern the statements and music of the defendant after April 2025. Further, if they are introduced, the jury will be greatly confused as they will have to do extraordinary or impossible mental gymnastics, which is, what he's doing is alleging that it would confuse the issues. He's making the allegation. You've got to say it'll do this thing that you're not supposed to do to justify your request to have them excluded under a 403 analysis. To determine what law pertains to what statement and what statements are actionable under the current case is pled, not to mention the mental gymnastics to determine what weight to give them in relation to the case. Thus, the evidence, if it is relevant, is not admissible and should be excluded from being presented and mentioned in the trial. So wherefore, the defendant respectfully requests that this court grant this motion in limine and enter an order excluding from evidence all songs, TikTok posts, and other materials created after the effective date of the Ohio's Uniform Public Expression Protection Act, and for such and other and further relief as the court deems just and proper. So there we go from David Osborne. So, and you know, if you're new here, we like to watch appeals oral arguments. You know, I think they're fun. I think they sharpen the mind. I think sometimes they get spicy. We watched 2 spicy oral arguments, I think last week, for the Anthony Sims case oral arguments. His conviction has been overturned. That's the prosecutor's theory of the case was a shooting of someone who worked at a Chinese takeout restaurant in Bushwick, that the motive behind it was beef over undercooked chicken 4 months earlier. That was the prosecution's trial theory. But it turns out the actual culprit, the employee, had made a sexual pass at their partner, like that day. So yeah, a little bit of a different motive there and different in time and space. So yeah, I should probably watch my phrasing. Yes, it was beef over chicken. It really was. And then we watched another oral argument. The Daryl Ewing, his conviction was previously overturned, and the appeal is by the state appealing the decision that overturned his conviction. So those oral arguments were great to watch. I have a playlist if you guys want to go to my channel and just look up like appeal arguments. You can watch our watches of them. And like the panel there was just pressing the state attorney, and they're like, well, wouldn't that be a discovery violation? And the state attorney's just like, no doubt. And one of the parties must have felt so confident. They had a law student with a provisional license do the argument in response to the state. And this is where I was going with this. So Happily Angry Lawyer, speaking of appeal arguments, is going to be doing Georgia State Supreme Court oral arguments that I think they took place today. But their website, if you watch them live, you can't pause or rewind or turn on captions. So he's doing the stream at 5 p.m. Eastern today. And I think Brian Steele and Andrew Fleischman are Hannah Payne's appellate attorneys. Now, Hannah Payne, I didn't watch the trial, but I remember the story. It was a big story. It was like vigilante justice, citizens type of arrest where something happens on a highway and Hannah Payne follows this guy and like miles away, drives, goes to his wherever he ends up parking, and then ends up claiming she had to shoot him in self-defense, and she was convicted. So if you guys remember that was like, let's see if he has a thumbnail where I can quickly show you the picture. Okay. Oh wait, I lied. He's doing a preview of it today and oral arguments tomorrow. So there we go. So tonight he'll be doing a preview, and he's just got Brian Steele as the thumbnail. And then that's Hannah Payne here. So if she looks familiar, that might trigger your memory on this case. So I'm going to link to today's video in the chat. It'll also be in the Creator Friends playlist in the description. And do I have the time right? Okay, so he's doing that one at 5 p.m. today, and then it seems like he's actually going to watch the oral arguments live, so he'll probably struggle with the pause button issue over there, so that'll be funny to watch him do. So there we go. Let me go back to W. Let's see if we have anything new. Nope, not yet. They're not back from lunch yet. And who knows? Like, anyone that came in late, a lot of people I've been trying to answer in chat when I see it, like, oh, did we miss Lisa's direct or cross-examination? Yesterday when court ended, the judge said we're going to start at 8:15 in the morning, and then the feed didn't start until like 9:20-ish local time. And it was in the middle of Justin Cooley's testimony. So my guess is that the media might not have gotten there until like right before 9 a.m. And by the time they got their camera set up, they'd missed the early part of the day, which unfortunately happened to be the rest of Lisa, her testimony. So we didn't get to see cross for her. With that, for the Holly Bobo judge decision for Zachary Adams, that deadline is end of the month. So I haven't seen anything yet, but as soon as I do, definitely going to go live to talk about that one. Yeah. All the pound cake is going to make the jury sleepy. Yeah, definitely disappointing to miss the cross. Because again, Lisa's the one that she's in the area on the video, and we had testimony from Randolph, Mr. Walters, that, oh, I gave my multi-tool to Miss Phillips, to Lisa Phillips. And Lisa Phillips is the one singing in the video near where the wiring for the surveillance system is. So I wanted to see that. I wanted to see her questioned about that. But who knows, maybe she'll be called back. Some of these witnesses, I think the defense stated kind of assertively that they were planning to call Brian Newland back, so the first witness. And they have on their witness list, they're like, hey, even if the plaintiff calls these people, we also want to disclose that we might call them too. So, and let's see. Yeah, singing Lisa, Do You Love Me? A Drake and Afroman collab. Let's see. Yeah, Hannah Payne recollection was odd for sure. So it's good. I haven't seen feedback on the trial. I just know it's one of those you kind of hear it like, all right, well, you followed somebody. But also, I guess, like legal analysis, self-defense can change. It can do some role reversal in an instant depending on how a state outlines self-defense. And, you know, I don't know. I think the best place for that is Hal's going to break down what the arguments from both sides as far as the brief. What were the errors that happened? Why should this conviction be reversed? And then obviously the state's opposition to those arguments. And then, of course, oral arguments tomorrow. So I think that'll be interesting to see. And again, it's Brian Steele and Andrew Fleischman. I don't know who's going to do oral arguments, but both. I mean, I enjoy watching Brian Steele. I enjoy watching Andrew Fleischman do oral arguments. I think it'll just be great, thoughtful arguments. And I don't know what person from the state's going to do arguments either. With the briefs, you can narrow it down for the appellant. But when it comes to the state for the briefs, they just have like this long, monstrous list of all the state attorneys that might have touched the paper. So you never know. So, yeah, we're still not getting any... It's been like a year for the corn rate guy. And all I know about that is that recording, listening and trying to hear if he's either counting numbers, like 1, 2, 3, 4, or calling her a derogatory term. So, oh man. Let's see. Yeah, hopefully they come back. Let's do a refresh. Let me refresh over here. Yeah, so I still don't see after refreshing. They're gonna be late. I know it. We're gonna start this stream and it's gonna be mid-sentence, mid-question. So, and it's supposed to be a new witness. Maybe. Yeah, I don't know. What if it's Michael Robinson? Let's see. And just hopping over here, you know, because I was curious, like, oh, maybe they're just late to start the broadcast, but they're actually recording the whole footage. So, but I don't see any videos uploaded where it's like after the fact they upload the missing parts of the day. Unfortunately. That sucks. How many plaintiffs in this lawsuit? Let's see. All right, so Shawn Cooley, Justin Cooley, Michael Estep, Shawn Grooms, Brian Newland, Lisa Phillips, and Randolph Walters, so 7. If you guys want a link to that. I think I linked to a Drive folder in the description of this video where you should be able to look at some of these filings. I haven't put the whole docket in there. So if you're on Replay Crew, check the description. In the chat, here's a direct link to the first amended complaint. If you want to check that out. We also did a stream on that over the weekend. So... And I just got, my thumbnail just says, what the heck are they doing? I couldn't get my head around how this was going to trial. I'll just call this the weekend stream. And there is a playlist in the description. It'll say like Afroman trial case playlist. And it's got all my streams on the trial, but it also has like, I'm not a lawyer, but has some videos in there. I put in some videos from Afroman's uploads for some of these relevant, like what he's been uploading this week, as well as like the lemon pound cake video. So if you want a quick way to find those, obviously, I mean, the easiest thing would probably just go to Afroman's channel and watch as you please. But for some of the other stuff, just go check out that playlist. So yeah, they're on lunch until, all right. All right. Adam is on it. Shout out to Adam in the chat. Let me get to the beginning.
Thank you, sir.
Okay, go ahead and be seated, everyone. So, ladies and gentlemen, hope the lunch break helped you. We did our housekeeping while you were getting assembled back there, so I think we're ready to go with the afternoon. We're still on the plaintiff's case, so Mr. Klingler's got another witness ready to go, right?
Right.
Where'd he go? There you are.
Are they ending their case soon? Are they resting soon?
The plaintiff's called Michael Robinson.
Yeah, it is Michael Robinson.
The defense would renew its objection contained in the motion limiting file stamped March 16th. That was certified at that date.
Thank you for filing the motion in limine. No, if you overrule the objection, and then that preserves the original. Very good. Go ahead.
All right, if you wanted to check out that motion limine to exclude Michael Robinson, we read that at the beginning of the day before the court feed started up. So you can run through that. But the short story is this guy's from a neighboring sheriff's office, and he independently reviewed this claim of the stolen $400. And it was disclosed, the report was disclosed like a couple days before this trial started.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, as this you shall answer unto God?
I do.
Thank you. You may be seated.
Okay. Go ahead. Please.
Thank you, Judge. Would you introduce yourself to the jury, please?
Certainly. My name is Mike Robinson. I'm a deputy sheriff with the Clermont County Sheriff's Office and been employed there for 35 years next month.
And can you tell us your current position and responsibilities with the Clermont County's Sheriff's Office?
Sure. I'm assigned under the investigative section with the Clermont County Sheriff's Office. I'm an evidence technician. I'm a certified evidence technician through the Miami Valley Regional Crime Laboratory. I am a certified
I'm going to object. He's testifying to stuff that was not contained in the report that was provided to us, nor anything about his background was provided. This is improper to ask this at this point. It was not disclosed.
His name and his purpose here were certainly disclosed. I'm simply giving background information so the jury knows who's talking to them. He can certainly be cross-examined by Mr. Osborne if Mr. Osborne finds anything that he wants to question him about, but...
Is there a written report?
There is.
Was that provided?
It was.
Did you not read the motion in limine?
The request is contained in my motion in limine, the email response to it and everything, noting the dates and times. There is no CB attached to it. He is asking stuff that would paint this gentleman as an expert. Expert requires at least 28 days notice prior to trial. It was never disclosed 28 days before, so it does not meet that. Asking him his training and everything, which we were not disclosed of, puts us at a disadvantage because we had no ability to research it, and we would object to that or paint him as an expert when it has not been followed per the rules.
He's going to be testifying as a fact witness, Judge, as to the investigation he conducted into the alleged missing cash in this case.
So the amended witness list is March 11. I don't remember the date of the first witness list. So as a fact witness, that's how I took him also. So his qualifications are relevant. I understand the objection, and I overrule it, and you can go ahead.
Thank you, Judge.
Yeah, it is, thank you.
Continue, please. And your title is detective, is that how we should refer to you, or?
That's, yes.
Detective Robinson, you were talking about your certifications, I believe.
Yes, I'm a certified evidence technician through the Miami Valley Regional Crime Laboratory. I'm a certified CVSA examiner as computer voice stress analysis for the last 25 years. I'm also a certified Part 107 drone pilot through the FAA, where I head up our Clermont County Sheriff's Office drone unit and flight missions operations. I'm also...
Your Honor, I'm going to object again. What does the drone training have to do with this? Was there a drone flown? It was not in the report.
Maybe nothing.
It has to do with who he is, Judge.
Yeah. It's not right on point, but it doesn't hurt.
I'm also, I've been certified Cellbrite examiner, which is the conducting forensic cell phone data extractions. I also serve as a backup coroner investigator with the Clermont County Sheriff's Office, or a coroner's office.
Thank you, Detective Robinson. Did you have occasion to conduct an investigation into an alleged missing amount of cash at the Adams County Sheriff's Department, the evidence room in particular?
Yes.
And just tell us how you became involved in an investigation into that.
I was contacted by our administration, who was contacted by what I believe to be the former sheriff, Adams County Sheriff Kimmy Rogers, to conduct an investigation involving the alleged missing money.
And can you explain to us what your investigation consisted of? What did you do?
Well, I met with Sheriff Kimmy Rogers, and I wanted to conduct an audit, actually, of the property evidence room that consisted of monies that would be brought in or had been brought in by deputies, detectives, agents, and so forth. So we were given, when I say we, my partner and I, were given full access to that, where we counted monies that were brought in from other investigations and so forth.
And is it fair to say that your investigation really focused on an alleged cash discrepancy from a search warrant that had been executed not too long before your investigation?
That's correct.
And can you tell us any more about that investigation? For example, does the name Brian Newland ring a bell to you?
Yes. We were forwarded video footage, body cam footage, of the search warrant that was conducted, and I focused attention to the body cam footage that involved the money count. And when I say money count, there were actually two money counts. There was, from the body cam video footage, there was money that was collected from one room of the home, and there was other monies that were collected from another, what appeared to be another room of the home. So you had a money count in this room that totaled a certain amount, and then you had a money count in another room that totaled a certain amount.
And do you remember what the alleged discrepancy was? Maybe not in terms of numbers right now, we'll get to that, but just in general, what was the problem? There was something, an amount was recorded that didn't actually comport with the amount of money that was there, is that?
That's correct. So what was reported altogether was $400 missing, alleged to be missing. $390 from the first money count, from the one room money count, and $10 from another money count from the other room. So that totaled to $400.
All right. And did you review, you mentioned you reviewed some body cam. Do you know whose body cam footage that was?
That was Detective Newland's body cam.
Okay. And you reviewed that body cam?
I did.
And were you able to come to any conclusions after your review of that body cam?
So the body cam footage that I reviewed in the one room that was counted as $4,390, I reviewed that body cam footage, and it was clear to me that there was a miscount of $390.
And can you explain to us
190?
what it was about the body cam footage that led you to that conclusion?
Well, it's just also not the video footage. It also includes audio. So video and audio together assisted me to determine this, but it's clearly on video. Do you want me to explain?
Please do, yeah.
Please.
So what Detective Newland does in counting this money was, you can see as he starts, he lays two $100 bills on the ground. You can clearly see that. And as he's counting the money, you can see it in body cam video, such as I'll demonstrate as I'm talking. And you can hear him count. With $200 on the ground, you can hear him count 3, 4, 5, 6, 7, and then he shuffles the money. And then when he lays down on the $200, he lays a single $100 bill down, and now he's counting 7, 8, 9, 10. So what he's counting as $1,000 is clearly that he only has $600 in the pile. And as he continue on with the body cam video footage, he makes piles of 100, and there's several piles of 100, hence over $4,000. But as he's collecting the money from the piles that he made, he collects, you can clearly see on body cam where he's collecting as $100. It actually contains $110. Now you can clearly see this on body cam video where there's a $50 bill underneath 320s. He picks that up and he collects it as 100, but it's clearly 110. He had a pile over to, in the video footage you see it on his left side, he's got a pile over there and he counted of $90. So he has 3 piles of 100s now in front of him. He picks that up and he picks up what he collected as $90 and he calls it $390. So he writes down on a piece of paper $4,390, when in fact the $390 doesn't really exist.
And your review of the body cam convinced you that that was the source of the discrepancy between the $4,000 that was actually in the bag and the $4,390 that was written on the bag?
Absolutely.
Now you mentioned a second pile of money, or a second bunch of money that was collected from another floor or another room. Can you tell us about your investigation into that alleged discrepancy?
Yes. So in watching that body footage, now this is the monies, I guess, that were uncovered in another room of the home. I could not make a determination like I could on the other count. It just didn't provide me a clear, it was counted as $641 was what was written on the packaging material that was used, and counted as 641. When in essence, I believe when it was returned to the homeowner, I believe $631 was actually in the bag, a $10 discrepancy. I couldn't account for that on body video or the audio displayed, so I couldn't come to a conclusion to that amount.
So you, for this $10 discrepancy between 631 and 641, you were not able to determine one way or the other?
That's correct.
What happened to that money?
That's correct.
On the $390 discrepancy, you were able to conclude what happened?
Absolutely.
And did you draw any conclusions at all about the $10 discrepancy, even though you couldn't see anything on video?
Yeah, I didn't conduct an interview with Detective Newland. I didn't find it necessary, but I couldn't come to a conclusion of the 10. And I don't think it would be so far forward for me to conclude that that might have been a miscount. But again, I couldn't come to that conclusion. I don't know. Okay,
Fair enough. And did you know Detective Newland before you started this investigation?
No.
Did you know anybody or have any relationship with anybody who was involved in this, in the cash that you were counting and investigating?
No.
Did you issue a report as a result of your investigation?
I did.
And is that report part of, kept in the public record as part of your normal duties as a detective?
Yes.
Could we have, what exhibit is that, Natalie?
31.
Thank you. Okay, we're showing you Exhibit 31, Detective Robinson, and it looks like, first of all, do you, from this little snippet we're looking at here from the first page, do you recognize this as part of the report you issued?
I do.
And it looks like the report date is December 8th of 2022. Is that right?
That's correct.
Okay. And then can you go to the second page of the report, please? And then the third page of the report. And do you recognize this, Detective, as the beginning of your narrative report of your investigation and the results contained in it?
Yes.
And we're not going to, we don't need to take time right now to review everything, but down at the last sentence of the second paragraph, you wrote, "The monies returned did not equal to what was indicated that had been originally removed from the home." Did I read that correctly?
You read it correctly.
And that's referring to this cash discrepancy that you just talked about.
Correct.
And then let's go down a little bit further, and there in your report, there's some numbers there on the left, 1 through 7, with various numbers. What are those and why are those there? Just give us a little snippet of what you're doing.
I mentioned that I wanted to conduct an audit of the monies coming in that were brought in to the sheriff's office by deputies, detectives, agents, what have you, from scenes, to see if there's a pattern or an issue. There were nearly 70 items, 60-something items that we counted. We actually broke open the packages, examined what was on the packaging, the amount, and then physically counted the money in each package. In almost those nearly 70 packages, we did find 7 discrepancies in that money, in those money counts by various deputies, detectives, agents, whoever brought those in. I don't have that.
Does this make your impression any better of what this department does? Does it make the commentary on this department any less warranted, even though it should be protected under the First Amendment regardless, but we're here anyway, so since we're here, this points to why we should be able to comment and question it.
List, but, of those 7 discrepancies, 3
what are we doing?
Contained monies that were less than what was indicated on the package, with the highest amount being $5. 4 of those discrepancies, 4 of the 7, actually contained more money that was in the packaging that was listed on the packaging, and that highest amount being $2.40. And a lot of this involved some coin change, if you will.
Okay. And Detective, what did you conclude as a result, if anything, as a result of this investigation into the whole evidence room here at Adams County?
You know, this didn't cause any red flags to us that, that there was a huge issue or anything, that this is a common mistake.
Discrepancies in 7 out of 66 of the evidence envelopes they looked at for the purpose of doing this. And he's saying it's a strength that it's a common mistake. He's leaning on that by saying it's fine, it's common. Evidence room, 66 envelopes checked, 7 have a discrepancy. That's really problematic.
Of counting money and coin, it really didn't send us a red flag.
And
come on.
Then let's turn to the, no, hang on one second, I'm sorry. Yeah, while we're still at this page at the very bottom, this is simply, I think, reciting what you've just testified to. Can you just read that for us, starting with while counting out? Can you see your computer monitor, or is it?
Can you see it on this one?
Is that easier or
Actually,
not?
that's better.
Is it okay? Yeah.
Well,
feel free. Yeah, no. We can blow it up a little too.
Well, that's fine. While counting out 100 bills, 2 $100 bills was placed down on the ground and counted aloud by Detective Newland as being 2. The counting continues, 3, 4, 5, 6. Though you don't have a clear view of these bills being counted, the audio suggests that he has counted to the number 6. There is a pause and then it goes on. What seemingly is the arranging of monies in hand while the 2 $100 bills remain on the floor. Next you hear 7, and a $100 bill is placed atop of the other 2 on the floor. This is followed by 8, 9, and 10. This completes the pile the detective has established and collects it as $1,000. When it appears that he actually has $600. The video audio continues, and after counting out piles of money totaling $100 each, he begins collecting these piles, making a pile of $1,000. He makes 4 piles that appear to be totaling $4,000. With 4 piles remaining, 3 piles were collected and totaled as $300, and the third pile collects as $100. It is clear that it contains $110. This is what I was testifying earlier. A $50 bill and 3 $20 bills. The fourth pile he adds with the other 3 and states on audio $390 and records on a piece of paper $4,390. Though he records $4,390, the video audio suggests to me that he actually has $4,000. I believe this accounts for the alleged missing $390 associated with item number 1.
All right, thank you. And then you also describe your conclusion with the second bag, and I don't know that we need to read that. The jury will have it back in the jury room if they want to, but essentially you weren't able to account for the $10 from the second bag, is that right?
Yeah, in reviewing that video footage and watching and listening, I couldn't make a determination to that amount.
All right. And do you know, was this amount of $4,390 on the first bag, was that written on the bag or somewhere in relation to the bag?
He writes it on a piece of paper. I don't recall if it was written on the bag.
And he puts it in the bag then? Is that your understanding?
I believe that's what was done, yes.
All right. And the video shows that?
Yes.
Detective Robinson, was your report available to the public if anyone asked for it?
I would believe it would be, yes.
Do you know if Mr. Foreman here or anyone else associated with him ever asked for a copy of your report?
I wouldn't know that. All right. I don't know that.
Okay. Those are all my questions. Thank you very much.
We have to trust examination.
Thank you, Howard. So Detective Robinson, you did an investigation into, at the request of the Adams County Sheriff at that time, correct?
Correct.
And you actually went farther than he asked for. You actually went and did a complete audit of all 66 money bags in evidence.
I wouldn't say that that was farther. It was part of the investigation.
So he asked for you to audit.
That was my idea.
Okay, that's what I'm getting at. And out of those 66 exhibits, did you attach to your report a itemization of them?
Correct.
Okay. And each one you say the amount stated and the amount counted and whether it matched or not?
Correct.
You also indicate if the bag was sealed or not?
I did not indicate that, but they were all sealed when we examined them.
Okay. Oh.
Just
Oh, okay. So I'm putting, this is a further amount of exhibit 31 of the plaintiff. And so this would be the spreadsheet that you attached to your report?
yeah, and actually, yeah, that's correct. And it obviously states that there were some found what we indicated to be open.
And that would be unsealed?
Yes,
So when it says open on here, it means unsealed?
that's what we put in there, yeah.
Did you note whether each evidence bag actually had like the number of denominations, like 7 $5 bills, 10 $10 bills? Did
No.
you note that?
No.
Okay. Did you get a chance to observe the packaging that the original money was in that was returned to Mr. Foreman?
I believe so. I don't recall what that looked like, but I believe we had that ability, yes.
So you don't remember if there was the bills written on it, so many fives, so many tens and such?
I don't.
But if you had noted that, that would be in your report?
Not necessarily.
Why not?
I'm concerned with the total amount, really not, I wasn't concerned by denominations, but I don't recall if that was on the packaging or not.
But you would agree if you put the number of denominations of each series of bill that was in there on the front of the bag, you could determine whether you miscounted or not just by doing multiplication.
I'm not sure, perhaps, maybe.
You're not sure you can do multiplication, or you're not sure that you can count up that?
Well, again, I don't know if those denominations were listed on the bag or not. I just know what the video clearly shows me.
So your entire, so let's ask that question. There was 8 hours of body cam footage. How much body cam footage did you watch?
I watched all of the body cam footage, but focused my attention on the money count.
You watched all 8 hours.
I watched, well, I didn't count how long it was, but I reviewed I had the entire body cam footage. I reviewed the body cam footage, but I focused my attention on the money count. Now, if it was 8 hours, I couldn't say.
Okay. So, but you never put in your report anything about the money being left unattended or anything like that you saw in the body cam?
It wasn't my concern if the money was left unattended because, again, after reviewing the body cam footage and the count, and it was listed as $4,390. That's what was listed on the bag when the homeowner came to collect his money, and I believe to be $4,000 in that bag, and $4,000 was returned.
Okay. So there was a number here in your report. You talk about Do you recall what the total amount that was listed on the bag one was? You said it was how much?
I don't know if it was listed on the bag or not. I know that he was writing down in the body cam footage on a piece of paper, and I couldn't tell what the number was, but I could hear what he was writing because he was saying it as he was writing it, $4,390.
Okay. So he wrote $4,390 on a piece of paper with the bills.
Yes.
And that was put in an evidence bag.
To my recollection, yes.
And so your investigation, it's off by $390.
On that money count.
On
On
the
the
first
first count. Item 1, yeah.
And then the second count is off by how much?
It was written as $641 or listed as $641, and I believe the money that was returned was $631 when they counted it. So $10.
Okay. But you can't determine today what happened with that.
That $10, no, sir, I can't.
But you do make an allegation in your report what happened to it, correct?
I indicated in my report that confirming the miscount of monies of $390, it would not be so far to believe that it was a miscount of that money, but again, I couldn't come to any conclusion of what happened to that $10.
So when you said in your report, therefore, due to the history of proven miscount of money with item 1, it would not be so far as to believe a miscount of money occurred in item number 2?
Correct, that's what I wrote.
But you never put anything in here after that that said that you could not determine that, and that was just your guess?
Well, I certainly couldn't determine it, but I didn't, that's not written in my report as word per word what you indicated.
Well, if your report's open to the public, shouldn't it be accurate?
It is accurate.
Are we sure?
You're saying today, though, that you can't determine, but you said here in your report that you can determine. So explain to me what's accurate about that.
I indicate that it wouldn't be so far to believe that it was a possible miscount of the $10.
But it doesn't go on farther in that same paragraph after that to say that you could not determine it.
No, it doesn't say that.
Okay, that's what I'm saying. So that's
Okay.
not, this is not accurate to your testimony.
But that's exact, I mean, that's the fact. I cannot determine.
And so that should be in the report here.
I believe by reading that, you can believe that it cannot be determined.
That's how you read it.
That's how I read it.
Okay.
And you went and interviewed Mr. Foreman, correct?
I didn't interview Mr. Foreman.
Who did you interview in relation to this?
I didn't interview anybody in this situation.
Not even Dee Russo, the evidence technician?
Yeah, she was with us when we did the audit.
So you interviewed her?
It wasn't an interview,
Well, what was it then?
just indicating of what, providing what we needed as far as the audit concerned and the money count. And she was with us when the money was being counted.
So not to be mean to Dee, but so she was what, just fetching and carrying the evidence for you?
Well, she's in charge of the evidence property room, and that's how we made contact with her.
But you didn't sit there and ask her what she saw when she counted the money when it was returned to Mr. Foreman?
I didn't ask her that, no.
I'd like you to look at the second to last paragraph. I submitted a subpoena for the raw footage from Channel 19. Why would you submit for the footage of a news agency when you could have interviewed one of the people standing in the room there because she was with you the whole time as the evidence technician?
Well, I thought the raw footage may involve some assistance in while counting money, so that footage was in reference to the money being counted or returned to the homeowner.
So that footage is more important than a witness who stood there, who had power over it, whose duty was the responsibility to watch that?
I think video and audio are just as important. Just as in this case where it's clear for item number 1 with a miscount of the 390.
Okay. But your audit showed a discrepancy of over 10%
Of all of the money and evidence, correct?
I think it was 66 items and 7 discrepancies, with the largest one being $5.
So,
Yes.
So whatever that percentage is,
Okay. So roughly that.
roughly.
And each one of those was only off by less than $10 either way, correct?
Yes, less than $10, $5 and less, yes.
So even by your own audit, the second count, which is off by $10, is actually even an anomaly compared to the other 10% that was miscounted.
I'm not sure what you mean by anomaly, or are you saying it's unusual, or?
No, let's not get to unusual yet. So, let's go back to your testimony.
No, this is a jury trial.
So, you testified during your audit, you had 3 that indicated less, with the most being indicated missing $5 as a miscount, correct?
That is correct.
You then found 4 that had more money than listed, with a highest being $2.40, correct?
Correct.
So $10 is more than you found in the 10% audit, correct?
Yes.
Nobody can count.
Who did you send a copy of your report to?
I can't recall if I sent any copies. I may have, I just don't recall.
You sent a copy to Mr. Foreman, though?
I don't recall sending a copy to Mr. Foreman.
Okay.
The disclosure issue.
Did you look at the return on the search warrant?
I did not.
But as far as you know, it would have an incorrect amount of money on it due to the miscount?
The search warrant return should have $4,390 as one count and $641 as the other count.
Which adds up to over $5,000?
Yes.
So, okay. If I may have a second, Ron?
All right, Doug will be on Justice Serve TV Thursday. We
No
talked
further
about how they were
questions
going to
for
go
this witness
live.
At this time.
Very cool. Always love a Doug Weinstein appearance.
Detective Robinson, we're going to pull up this report one more time, and let me ask you just a couple questions about it to clarify what happened here. What exhibit is this, Natalie? 31?
Yes.
Looking at exhibit 31 again, the last page of your report, Detective.
Hetty Crocker is a great username. I love it.
You don't have to reset it.
Persistent flash?
6 p.m. Eastern on Thursday for the Justice Serve TV
I
episode.
wonder,
Just use the document.
we could do that.
Just set it down on the document.
Mine is marked up.
Your Honor, mine is not. We could use
Thank
mine.
you. Thank you for the accommodation.
Your Honor, mine, just for the record, mine does have one thing at the top that says Plaintiffs Exhibit 31, so I know what it is when I refer to it.
We're just going to use that, this one page.
Thank you. Flip the switch back.
Yep.
He's resetting it. I hope that doesn't mess us up here.
Technology's great when it works.
Yeah, the judge interjected like 5 times sua sponte during the first witness. So that's been interesting, EWB. I agree. Also, I shared in the chat, but I shared a playlist if you guys remember. It was like Charlotte Mecklenburg Police. It was one of the officers.
Your Honor, if I may ask, this
Was
might
seen-
be the perfect time for me to ask for a restroom break. We're not able to do anything at this time.
How long do you think this will stand?
I have 2 minutes, 3 minutes.
Make it?
I can try, Your Honor.
Fair enough.
He wasn't asking for a bathroom break, literally. He wants to get the tech together. I don't think the judge realized. But I was saying Officer Henry Chapman, I don't know if you guys remember, but he was arrested back in 2024 for allegedly stealing $900 from a suspect during a traffic stop. The Charlotte Mecklenburg police posted all the body cam, and you could see it happening, but he entered an Alford plea, so he is entitled to maintaining his innocence. I shared a playlist with those videos if you guys want to do a little throwback on that from 2024. It's like 10 videos. You can watch it. I think it's plain as day. And I'll throw it in the description as well of this video.
Thank you, Your Honor.
Perfect. Okay, go ahead, Mr. Klingler.
Thank you. Okay, Detective Robinson, we have this Exhibit 31 back up on the screen. And the page we're looking at has a second to the last paragraph there from the bottom. And you wrote, as I'm reading it, as to evidence item number 2 and the alleged missing $10 from the counted and recorded $641, I cannot determine from the body cam footage the amount possibly collected. Did I read that correctly?
You did.
And was that true?
That's true.
That's an accurate representation of your conclusion?
Yes.
While we're on this page, and since Mr. Osborne asked you a question about Channel 19 footage, I want to ask you about the short paragraph right above the one we just looked at, where you wrote, I would like to note that a news article published by WXIX reporter Ken Baker on August 30th, 2022, a week after the execution of the search warrant, the homeowner reported that investigators removed $4,000 from his home. Why was that important for you to include in your report?
I felt that if someone, this money was collected, I believe, if I recall correctly, from some clothing, an article of clothing, maybe in a pocket or something of that sort, that it would be strange to have $4,390 tucked away like that. It would make more sense if you had $4,000 maybe tucked away. And when I saw this article, I found it of some interest, so I put that in my report.
Okay. That's all I have. Thank you.
Recross.
Just a couple questions, Your Honor.
Look at the bottom of the
Detective
report.
Robinson, you found a news article of interest? Is that correct?
Yes.
But you
More
didn't
interest
interview
in
people.
interviewing anybody who was there, Brian Newland, Mr. Foreman, or anything?
I didn't find it necessary to interview them.
Wow.
So this news article, though, would have occurred before Mr. Foreman got back his money, correct?
All I recall and what I documented is that it was a week after the search warrant execution.
Do you even know when he got back his money?
Not at the top of my head.
So you don't know if he got it back a week or 10 months later? Is that correct?
Well, he didn't get it back a week later.
So
But
when he
got
made
it-
that
yeah, I
statement,
just-
he
I
did not
can't
have his
recite to
money,
you.
correct?
I'm sorry.
When he made that statement to the news, he did not have his money back, correct?
I don't know that for sure. But
Mr.
I don't believe
Robinson.
he did.
How about, let me finish, it's easy to step on each other. Go ahead.
Mr. Robinson, let's cut the crap on this.
You said he didn't have back his money a week after the raid, right?
I don't know when he got the money back. I don't recall the date. I'm assuming that it was a week after the search warrant execution that he did not have his money returned.
So when he made that statement, you would assume he did not know or have his money back from the police department at that time.
Are you saying he didn't know the amount of money or?
I'm asking you, based on what you just testified to, did he have back his money a week after the raid?
No, I don't believe he did.
Okay.
Did you call Ken Baker?
No, I did not.
No further questions, Your Honor.
No redirect, Judge.
Go ahead, step down, thank you.
Thank you, Your Honor. Thank you.
The plaintiffs called Joseph Foreman as if on cross-examination.
Woo! Hostile witness, Joseph Foreman, Afroman! Let's go! Let's go!
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? As this, you shall answer unto God.
Yes.
Thank you, sir. And have a seat.
Go ahead, Mr. Klingler.
Thank you, Your Honor. For the record, would you give us your name, please?
My name is Joseph Edgar Foreman.
You are known under the stage name as Afroman, is that correct?
Yes, sir.
And you create music videos and do performances, is
Yes,
that
sir.
right? How many states of the United States have you performed in, do you think?
All of them.
All 50?
Yes, sir.
That's
How many countries have you performed in?
I don't remember, but not all of them, but I've been to a few.
How many live performances did you do last year, roughly?
I don't know, possibly 250. I don't know, but I don't know. It's a lot of days, but I don't know exactly.
And you have a residence here in Adams County, correct?
Yes, sir.
You've been performing for 20 or 30 years, is that right?
All my life.
All right. And is it fair to say that one of the first big hits you had was But Then I Got High?
Because I got high.
Because I Got High? And do you think it's accurate to say that that song has had over 300 million views on YouTube?
Sounds right.
You have a large presence on social media, obviously, correct?
Depends on your definition of large. There's bigger people than me, but I'm all right.
And on Instagram, is it fair to say that you have 247,000 followers?
Yeah, I just got some of them the other day.
This trial.
You got new ones coming all the time
Yes. Not all the time, just here lately.
because the trial's coming up?
Yeah, all the publicity from the officers lawsuing me is running up my numbers.
Yeah.
That's right.
And on YouTube, you have almost 1 million followers, 983,000, is that right?
I haven't looked, it was 977 last time I looked.
And on TikTok, you have about 392,000 followers?
I haven't looked at it, but that sounds kind of right.
You know when you post something that a lot of people are going to see it, don't you?
Yes.
When this search happened back in August of 2022, Mr. Foreman, you weren't at home?
No.
You were driving home from Chicago?
Yes.
And you got an alert from a family member that the sheriffs were there searching your home, is that right?
Yes.
And you were able to turn on your phone and watch through your home security system what the deputies were doing for a period of time, weren't you?
Yes.
And is it fair to say you were angry and upset about this search?
I wasn't happy.
And is that why you posted the things we've seen this week, because you weren't happy?
No, I posted it because the sheriff's never supposed to raid my house in the first place. The whole raid was a mistake. All of this is their fault. If they hadn't have wrongly raided my house, there would be no lawsuit. I would not know their names. They wouldn't be on my body. They wouldn't be on my home surveillance system. And there would be no songs, nothing. My money would still be intact, nothing. So all of this is their fault.
And because they executed a search warrant on your home, that gave you the right to post the things that we've seen this week on the internet?
Wow.
Because
Is that right? Is that right, Mr. Foreman?
Yes, for
Yes.
tearing down my door, not paying for it, not being apologetic, me being a sport, doing something peaceful to raise the money to pay for their damages, me having the right of the freedom of speech as an American to talk to my family, friends, and fans about what the sheriffs did to my home. Yes, I had the right to my freedom of speech. After they left, I had the right to kick the can and to do what I had to do to repair the damage they brought to my house. Yes, I did.
That includes the right to post the videos that you've just been posting up until Friday and beyond, right?
Yes, I have freedom of speech. I'm a rapper. I entertain. I write fiction, comedy. Yes, I mean, I entertain for a living like you practice law for a living. So I have to go to work.
We're both jokes. No.
The deputies left a warrant return at your house, didn't they?
I think they left something with my ex-wife. I'm not sure.
Well, you saw, as soon as the search was over, as soon as you got home, you saw a document that showed exactly how much cash had been taken from the house, correct?
I know I got paid $5,000 for the show that suit was in. I forgot that money was in that suit. But, I heard, I don't know what piece of paper I heard. I knew they took some money. I just knew they took some money. I knew it was 4,000-ish. I knew they took some money and they seized some money and some weed and some, I don't know what else, just minor stuff.
You knew how much money was in that pocket when you came home and saw the warrant return, didn't you?
It was $5,000 from back when I did that show. I remember it was $5,000. But anyway.
So is it your testimony that they actually took $5,000 instead of $4,390?
No, I just know. I know when I did that show, it was with Snoop Dogg and Wiz Khalifa at Red Rocks in Denver. The balance of that show for me, they sent in a deposit, but the balance was $5,000. I put the $5,000 in my coat pocket. I got drunk, I got high, and I forgot to get that money, and I hung that suit back up. And that's where they got that money from.
So it was $5,000 they got?
Yes, it was $5,000 that was in my suit when I got paid in Red Rocks. Now, after all of this stuff, you know, whatever, it's, I don't really know the complete number. It's 46, it's 430, the number bounces up and down. But all I know is I got paid $5,000 at the Red Rocks with Snoop Dogg and Wiz Khalifa when I played the Red Rocks in Denver.
And you got $4,000 returned, right?
I don't know the exact amount.
Well, you were there with the news when you got it.
Right, and the lady at the sheriff's station admitted that the sheriff's was short. You can go watch the 19 News.
You knew when you saw the warrant returned, didn't you, that the amount that they were saying was taken was actually more money than was in that suit pocket?
I didn't warrant.
That's why you brought the news to the sheriff's office when you got the money back, because you knew that they had miscounted the money and the number on the evidence bag was actually more
I didn't know
money.
nothing. The lady at the sheriff department just volunteered the information. I was sitting there, you know, if she had been, I might not even known I got ripped off. She admitted it live on Channel 19 News that the money wasn't right.
You remember in your deposition when I asked you, why did you bring the news when you picked up the money?
Yeah, I didn't want to get beat up or Epstein at the sheriff's station after I seen him running around my house with AR-15s. So that's why I brought the news and my attorney. So to make sure I got out of that place with my money.
You brought the news to protect you physically.
Yeah.
Yeah. You didn't bring the news because you already knew there was a miscount and you were going to make.
I didn't know nothing about the miscount. I didn't know. I figured they stole my money. They turned my cameras off. So if you turn my cameras off, you must got something bad in mind. So yeah, I'm accusing them of it. You know, they turned my cameras off. I can't see what they're doing.
So your testimony under oath here today to these 10 jurors is that you brought the news when you picked up your money to protect you physically from being beat up or shot by the sheriffs, right?
Yes.
All right.
And they volunteered the information that the money wasn't right. That's just an extra something we found out. But I came with my attorney and the news to make sure the people running around my house with guns didn't take me into jail and do something.
You had a safe in your home, correct?
2 of them.
2 safes. Did the sheriffs look into those safes, to your knowledge?
Yes, they did.
The deputies?
Yes.
And how did they get the combination?
I gave it to my ex-wife so the sheriffs wouldn't pull my safe off the floor, take it to the station and put something in it and try to say that whatever they put in my safe was mine. So I went ahead and gave my ex-wife, who I didn't want to give my combination to, it was just safer. I went ahead and gave her my combination so they could open up the safe and realize that they just vandalized somebody that don't even have nothing in the safe.
And do you know what was in those safes?
It was absolutely nothing in the safes.
Don't you keep jewelry in those safes?
No.
Didn't you tell me that in your deposition, that you keep jewelry in those safes?
I do.
Was anything missing from the safes when you got home after the search?
I didn't put nothing in the safes.
Was anything missing from the safes when you got home?
Nothing was in them, so nothing was missing from the safe.
You talked to Randy Walters on the phone before you got home that evening during the search, or right afterwards, didn't you?
Yes, sir.
He told you that they were taking some money and some vape pens and a small amount of marijuana. He told you that?
Yes, sir.
You knew, didn't you, Mr. Foreman, that there had been an investigation by the Clermont County Sheriff's Office into the discrepancy about the cash that was missing from your home, correct? You knew there was an investigation.
Yeah, I knew the sheriffs was investigating themselves.
Oh, that's how you saw it?
Yes, sir.
Okay. And did you ever ask for a report so you could see how bad this investigation of themselves really was?
Yes, I was trying to get involved any way I can. The investigation was going on without any of my participation.
Did you ask for a copy of the report?
I did. I asked for everything. I was trying to be involved. I didn't.
So you've seen the report?
No, I have not.
Okay.
I just saw it a few minutes ago.
Well, You had an attorney when you got the cash returned, correct?
At the station,
Yes.
I had attorney, yeah, my attorney was present.
Did
when
your
I got my
attorney ask
cash.
for a copy of this report?
It wasn't in it, when I got my cash back from the station, it wasn't an investigation until we realized money was missing.
Well, did you contact your attorney and say, hey, get me a copy of that report?
Your Honor, I'm going to object. Well, Mr. Klingler wants to talk about his client's attorney-client privilege in every way, but Mr. Foreman does have attorney-client privilege with his attorney at that time. And we are going to assert that privilege because it's a privilege he has of right.
And so far, he hasn't asked anything privileged. So I appreciate the sensitivity, overrule the objection.
Sensitivity. The noise.
Go ahead.
Thank you, Judge. Your testimony is you never saw a copy of Detective Robinson's report until today.
Yes, sir.
And that's because you didn't want to see a copy of the
I
investigation.
did want to see, you don't know what I want. I did want to see.
You did.
I wanted everything that had something to do with my money coming.
And that was 3.5 years ago, correct? And you haven't seen a copy of that report that you wanted to see until this afternoon. Is that right?
That's
Why would
right.
he know?
I never had my money taken by cops. I didn't know how this go. I don't know about reports. All I know is live on Fox 19 News, the lady admits that her department is short $400 of my money. That's all I know. I don't know how to investigate police officers taking money.
That's all you know, and that's all you know today, isn't it? That's the whole basis of your claim that your money was stolen, is that the amount of money that was in the bags is different from the amount of money that was written on the bag.
Yeah, my whole thing
Yes.
is they never should have raided me in the first place.
That's your whole thing.
That's my whole thing.
That's the
That's my
point,
whole
isn't
thing. If they never would have showed up, there would be no songs about them. I wouldn't know who they are. Their faces would not be on my video cameras. None of this, we wouldn't be in this room right now if they hadn't have raided my house and didn't press no charges, didn't even know what they was doing. This whole thing is their fault, and they're suing me for their mistake.
And so you don't really care if they stole your money or not. You're just mad
I
about
do
what they
care about
did.
if they stole one.
But
Police officers shouldn't be stealing the civilians' money. So I do care. All of it is an outrage. This whole thing is an outrage.
You have no evidence that they took your money except for the amount on the bag isn't the same as the amount.
How about the
got
lady
returned.
admitting that she took?
Could you answer my?
She admitted that she took my money on live Fox 19 News. Go argue with the film clip.
Yeah.
Go argue with her admitting that she took my money.
Nobody admitted that they took your money.
Well, whatever. Go look at her admitting that the bag is short
Mr.
because it
Foreman.
stayed open all weekend long or 2 weeks after Brian and Officer Cooley just left it and just mishandled it and didn't do right.
Just so we're honest with the jury here, Mr.
Wow.
Foreman, nobody admitted that they took your money, did they?
They admitted it was short.
Yes.
So
Nobody
it looked like
admitted
somebody
that they
took-
took your money, correct?
It was short. She admitted. She said that it was short.
So
And
I would
usually
believe it was
it's
missing.
$10, $2 missing. How does $400 even come up missing? Odd.
Pause.
You posted videos about Brian Newland doing hard drugs and snitching on his friend, and you posted those based on rumors, didn't you? We can look at your deposition, but before you argue with me, but isn't that a fact that you made those allegations based on rumors you said you heard?
It's a fact. William Newland is a convicted pedophile, and Brian Newland is his brother. After I zeroed in on Brian, I asked about him. Come to find out, he's a large statutory rapist that has sex with all kinds of underage girls. He buys them beers and gets them drunk and all kinds. That's probably the reason he had to leave the Adams County Sheriff Department, because he beats up his wife and he messed with underage girls, and he had to get out of town and go get a job in Norwood.
All right. You don't want to answer my question.
I do. Please ask another one.
Well, let me ask this one again
Oh my
so I can
God.
get an answer. Do you remember in your deposition when I asked you, you have no reason to think these rumors about Brian Newland are true, do you? And you said, well, it's more entertaining if it's true, and I can make some money. Do you remember that?
No, I don't. That's a however long that deposition was. You can read the deposition and it tells you what I said.
Do we have a copy, another copy of that?
Oh,
'Cause I'll
yeah,
show
let's
to
read
you. I
it.
can show you my copy. Refresh your recollection.
He's gonna refresh his recollection.
It's,
Trees. You then use the
thank you, Judge. If I can get it working here.
Your Honor, I would object to using the screen to refresh his recollection.
That's Newland.
If he wants to refresh his recollection, he can show him it and then ask him a question, much how we would do in criminal law with a police report. If an officer didn't remember, we wouldn't show the report, we would show it to the officer. He would refresh his memory by reading it, and then we'd re-ask the question.
Do it that way, just make sure you think he reads it right. I'm just trying to get through the verbiage. Just make sure you think he reads it right, otherwise I have to wrestle with you about whether he read it right.
Sure.
So just read it. And then if we want to move it as an exhibit, you can do that.
Remember your deposition being taken, Mr. Foreman, in your attorney's office on September 3rd, 2024.
I remember the deposition.
And that deposition was taken in DJ Osborne's office?
Yes, sir.
That's the same office that you used to film that video that we saw last
Lisa.
night with the actor playing Lieutenant Lisa Phillips, and that actor was sitting in the same chair that Lisa Phillips sat in during her deposition, wasn't she?
Yeah, the actor played
Treya.
Lisa, because I wouldn't have known her if she hadn't came to my house and cut off my camera.
Yeah, right.
Right.
That's the office we're talking about, and that's the office where I took your deposition, right?
Yes, sir.
And in that deposition, I'm referring to page 84 of the deposition. I had asked you
Your Honor, I
about,
object, he's testifying.
No, he's used the deposition to refresh his memory. He's doing it right, so sit down, please.
Sit down.
did I ask you this question, and did you give me these answers, Mr. Foreman? Question, would it be fair to say these are rumors? Answer, you know, Stephanie said it, and you know, some other people that don't remember, you know, I'd be in a hurry in Walmart or something, they shake my hand, yeah, Brian used to do this, used to do that. Then something, I didn't know him, but this is what I've heard. Question, you don't have any particular reason to think that it's true or not true, right? Answer, well, it's more entertaining if it is true, and I could probably make some money and capitalize on it if it's true.
What are the line numbers?
Starting with line 7 and ending with line 21.
All right.
Did I ask you those questions and you give me those answers?
I don't remember. That was a long time ago. But
But that's my question.
I've always
Thank you.
put Brian Newland next to his brother. So that's
Yeah.
my basis, and I've always...
We noticed that.
Yeah,
And
yeah,
your
so-
attorney's going to be able to ask you whatever questions he wants. Right now, I'd like you to focus on my questions, Mr. Foreman.
You can see his eyebrows raised behind the glasses.
You have no evidence that Brian Newland ever molested little boys, do you?
If you look at the picture, he's holding the little boy's butt. It's too much for me. So if you just use your eyeballs, again, his brother's a convicted pedophile.
That's your evidence for posting that pedophile stuff.
Hey,
about
I'm just
little
trying to
boys.
figure out. I'm trying to figure out what kind of guy is kicking on my door. What kind of guy is walking around my house reading my bank statements? It's a dude. It's a dude that's possibly a pedophile, got a convicted pedophile brother, deputized by the sheriff, walking around, possibly stealing my money. I'm just trying to figure out what's going on as I zoom in with my cameras. That's not the type of guy I don't think should be on the police force.
I'm going to refer you again to your deposition. If you don't trust my reading of it, I'm happy to give it to you, Mr. Foreman. But on page 98 of your deposition, on that same day, beginning at 9/11, did I ask you this question and did you give me this answer? And again, the only evidence, you don't have any evidence that Brian Newland is a pedophile or plays with little boys. Answer, no, sir. Did I ask you that question? Did you give me that answer?
I don't remember.
Beginning with line 11, ending with line 14 on page 98. You have no evidence that Lisa Phillips stole your money, do you?
I know if she hadn't raided my house, we wouldn't be having this conversation. Nor a lawsuit or nothing. They never should have been at my house.
Since you're not going to answer my question, I'm going to go back to your deposition again, Mr. Foreman, page 102.
Your Honor, if I may, can I just enter a continuing objection so I don't have to object every time he does the deposition?
No, it's too important, so please be specific. Thank you.
So I would enter a notation of objection at this point. He is now testifying for the witness. He is no longer refreshing his recollection.
I'll be sensitive to that, so you can rephrase and also sustain that. You made the conclusion you didn't have memory, so you've got to go back and fix that.
All right, Judge, I will. Thank you. Do you remember telling me in your deposition, Mr. Foreman, that you don't have any evidence that Lisa Phillips stole your money?
Yeah, she cut off the cameras, but I didn't know who took them. I didn't know who took them. So, all the officers was a suspect at first, because I didn't know where. After the deposition, I realized that Brian Newland was in charge of the money, and I knew where to focus everything. But at first, all the cops was a suspect, especially after they cut off my cameras, and I couldn't see what they were doing.
All right. Well, so you don't remember? Is that what you're telling me?
I remember telling you that Lisa, probably didn't take my money,
Okay.
but I just didn't know. I just knew it was missing, and they cut off my cameras, so all of them were suspects until I figured it out.
So until you figured it out?
Until everybody figured it out, until it was solved of where the missing money was.
All right. So just to clear this up and move on, you admit that you don't have any evidence that Lisa Phillips stole your money?
No. But I know if she wasn't there in the first place, we wouldn't be having this conversation or be here.
And is it true that one of your big motivation, really, in making all of these posts is to make money?
To pay for the damage that they brought to my house under the circumstance that they shouldn't have even been there in the first place.
Okay. So the answer to my question is yes, your motivation was to make money?
To pay for the damages that they brought to my house under the circumstances that they shouldn't have been there in the first place.
Have you made enough yet to make up for it?
How much you paying your lawyer?
Not really, you know.
How much have you made on it?
I don't know exactly, but it wasn't hardly $24,000.
$24,000.
It wasn't that. It wasn't that.
You're still making money on today, right, with the new posts and advertisements and things?
It's publicity.
You're still selling merchandise, aren't you?
No.
I couldn't order.
Just me, just everybody. Thanks to them bringing publicity to this, it's just an opportunity to run numbers up and be an entertainer.
And the more lies, outrageous lies you tell about them, the more money you can make, right?
Fact, they never should have came to my house in the first place. Fact, if they hadn't came to my house, they wouldn't have put themselves on the video camera and in my music career. All of this is their fact. All of this is their fault, and they have the audacity to sue me. These people and you are the predators and the victim at the same time.
So what they did, searching your house, gave you the right to do everything you
Under the circumstance that I got freedom of speech, after they run around my house with guns and kick down my door, I got the right to kick a can in my backyard, use my freedom of speech, turn my bad times into a good time. Yes, I do. And I think I'm a sport for doing so, because I don't go to their house, kick down their doors, flip them off on their surveillance cameras, then try to play the victim and sue them.
You were at Lisa Phillips's deposition, correct?
Yes, sir.
In your lawyer's office?
Yes, sir.
Same office where you filmed part of that video last Friday?
Yes, sir.
And you saw how upset she was when she was answering your lawyer's questions about how this had affected her, right?
Yes, yes,
And you saw your attorney say, do we need to take a break?
yes,
And you saw her say, no, let's go on and get this over with.
yes, sir.
You saw all that.
Yes.
We missed that this
You knew
morning.
she was upset.
Just like she knew I was upset when she was standing in front of my kids with an AR-15 with her hand around the trigger ready to shoot me. Just like she knew I was upset when she cut my cameras. But I'm not a person, she is. So I'm sorry for being a victim. Let's talk about the predators.
Okay. So you saw all that. You saw how upset she was. You heard the testimony about her children. You heard the testimony at the depositions about Randy Newland's daughter who came home upset. You heard all that. But you're still posting stuff about
Yeah,
it.
because I understand it was Randy's fault and all of their fault for coming in my house in the first place. So if they hadn't came to my house, their children wouldn't be saying nothing. None of this would be going home if they did their research and did things right. So all of this is their fault. And now they want to sue me for their mistake.
The silence after some
Is
of
there
these
anything that
moments.
could change your mind about what you're doing to these deputies?
Is there anything that can change my mind about the fact that they shouldn't have been at my house in the first place? Is there anything that can change my mind about how my money shouldn't have been touched in the first place? No.
That's all the questions I have. Thank you.
You're welcome.
The pan, look at the gallery. Look at the plaintiff's table, chat. This guy, his head is inside his collar. This guy.
I'm sorry, Mr. Osborne. I'm going to continue the direct examination of your client now.
Your Honor, I was going to actually ask for a sidebar so we can talk about that.
Okay, so let's just talk about it.
Okay, so I was actually going to not do cross with Mr. Foreman this time. I was going to hold off until our case in chief.
Yeah, I just offered you the chance to do that. So do you want to do your direct examination on your case in chief right now?
Not right now.
Like the pogo stick of witnesses up and down is what I was talking about. If he testifies on his own direct case, it could be now or it could be later. I just gave the lawyer a chance to do it now or later. He said later. So you'll likely see Mr. Foreman again. This was an examination on the plaintiff's case. You get a chance to hear his testimony on his case. There's your explanation. Thanks, Mr. Foreman. You can stand up.
Plaintiffs rest subject to the admission of all our exhibits.
Oh, that's it.
Okay, thank you. We'll deal with the exhibits on a break. What do you have?
I had no one ready. All my people were subpoenaed to be ready tomorrow. I will have to call them to get them here in the morning.
Don't research. Don't think.
Don't eat pound cake.
Talk. Ruminate in your own mind, maybe, but it can't be any farther than that. The admonition we talked about previously about deliberating as a group and thinking collectively is still in play. And you can't look at anything on
Oh. No, why'd they?
is still. Don't talk. The admonition we talked about previously about deliberating as a
They
group
cut out
and thinking
mid.
collectively is still in play. And you can't look at anything online. Can't.
Yeah, so they just cut out mid. What testimony? This is crazy. You know, when we watched the YSL trial, there were several things that we had to watch more than once. I don't know if the defense case in chief, if they're going to call Afroman back to the stand tomorrow afternoon or, you know, maybe Thursday or something. But on a lunch break, we might rewatch this segment of testimony again whenever it's close to when he takes the stand again, because that was crazy. So, I mean, maybe he's in a little bit of danger for a jury having sympathy on the very explicit, specific claims about the sex change for Lisa and the statutory rapist claim against Brian Newland. But I don't think this is going to end. I think we're going to hear more about the basis for belief with the defense's case in chief for some of the stuff going on with kids, particularly as it relates to Shawn Grooms. But this idea that if you're questioning everybody as a group and you don't have information at the time who was where, the camera footage was cut, is it not just a reasonable inference to think the cops took your money? There's a number amount on an envelope and I do not get that money back. And I could have had that amount of money before they took it, so it's not like the mistaken calculation is out of this world, out of this realm of possibility. So if the numbers are a mismatch, I'd be asking too, where's the rest of my money? Look at this. This says something different. And the money you gave me is less than this. So I don't see how... I would be really, really mad if somehow someone's not allowed to challenge somebody on that. And it doesn't matter to me whether somebody decides to just make a Facebook post about it or make a music video about it. If it's something I was going to gripe about, I'd gripe online. I wouldn't have the production capability to go and sing a song. You guys wouldn't want to hear that anyway and make a whole song. But either way, it's still an expression. And I think it should be even more protected because it's an artistic expression. So, I don't know. Like, and like what plaintiffs, like all of the witnesses have been asked about being called a thief. Like, can you not comment on a police officer being a thief? It's not even like this is a statement on somebody just out of the blue, a random private citizen. It's specifically related to this raid on the home. So, but yeah, I guess they're ending court early today. It's only 2:30 here. I'm thinking the judge probably wanted to go till 5, but plaintiffs rested their case. Maybe they expected that he'd continue with his version of direct with Afroman and this would go longer. I don't know. And this trial on the docket, you guys, I saw that the week is slated for trial days. I didn't see anything for next week, so I think this should wrap up in the next few days. As far as housekeeping, if you guys tuned in today, if you had no idea this was going on and you want to go and rewatch day 1 or look at some more motions from before trial, there is a playlist in the description, right? So I've done 3 streams on this. This is the 3rd stream where we've looked at this, day 1, today's day 2, and pre-trial stuff. So you can catch up through that. I've also included a bunch of like the exhibits that have come in, some of the music videos that he's posted, and other analysis commentary creators that have commented on this case in that playlist as well. So since it's an early day, you guys have time if you want to go dive in and check that stuff out. This would be a great time to get caught up. And remember, some of Afroman's videos are like 10 minutes each, so it might take some time to get caught up. We've got, let's see. I also want to give a big thank you here during that testimony, which I didn't want to interrupt. That was a time. Roosevelt, thank you for becoming a member and dropping a 10. Thank you for the love. Thank you for coming and hanging out with us. Black Butterfly came in here and was like, hey, did you add a pound cake emoji? We need one. So thank you for the 2. There is a pound cake emoji. Use it to your heart's content. And then Romy becoming green, which means Romy can now use the cake emoji. So use those to your heart's content. It's been fun. I don't know if you guys noticed, but I changed to one picture having the slice missing after we watched the body cam. So, good old times. And, what else do we got going on? Chat saying, check the Ben Nandy trial. Let's see. All right. And this is a side story, you guys, we've been following. It's a cold case that doesn't have cameras in the courtroom, but Ben Nandy has been reporting on it. It's an Orange County, New York case, cold case. And the jury's been deliberating. Is this day 12? Is this day 12? They've been asking like crazy questions. They've asked, yesterday, the count was 27 questions that they had asked. Let's see. They read an Allen charge yesterday, first trial, hung jury, and then a quick update from today. Ben Nandy says, should a juror be allowed to have a pocket constitution in the jury room? This came up recently during deliberations in the second murder trial of Edward Hawley. The judge said a court officer noticed one of the jurors holding a pocket constitution. I'm not sure how it was resolved. The judge said it might seem innocuous. The jury's said though it might seem innocuous, the jury's only supposed to be using evidence and testimony presented at this trial to make a decision on whether Ed Hawley is guilty. Hawley is accused of killing his ex-girlfriend Megan McDonald in 2003. The jury sent its third deadlock note yesterday, was told to keep trying, and has not submitted a note to the court since. So somebody in that jury room carries a pocket constitution, and a deputy seems to have been the one to bring it to the court's attention. Right? This doesn't seem like a jury question. This seems like the court officer brought it to the attention. So yeah, this is the same jury that asked if they can Google DNA. It's been a time. So thank you very much for everyone tuning in. Kind of interesting that we're getting this tidbit from a random case. We got 2 hot messes going on. We'll be back tomorrow for day 3. Again, since we don't know, the judge had wanted to start today at 8:15, and the camera in control of the camera pool, they didn't start broadcasting until like 15-20 minutes after 9 this morning. So we missed the rest of direct and then the full cross-examination of Lisa. We missed the beginning of today's first witness. I'll go live when I see them go live. We won't miss anything that's available to them, but plan for around 9 a.m. tomorrow as well. It's going to be Osborne calling witnesses. It's going to be the defense's case in chief. So I think it's going to get even more entertaining. So thank you so much. It's been awesome to have new faces in the chat, seeing some old faces come back around, and then having people that are usually here, everyone coming together and having a good time talking about this case. Differing views are welcome here, as long as no personal attacks in the chat. Hope you stick around. Thank you so much for a great day. And I want to give a special shout out to Drea. Drea's been busy. She's actually, a while ago, she's like, hey, I'm taking a new position. I'm going to be the bakery manager. I'm not kidding, you guys. She's going to be the bakery manager. This was like a year ago she said that. She's been busy ever since. Drea was my first mod. I modded her in a panic when I read a Brian Steele motion, and all of a sudden 3,000 people were in the chat, and I'd never dealt with that before. So I just panicked, and graciously, Drea took the wrench, wore it proudly, and helped me out. She got this job, and tomorrow she said lemon pound cake coincidentally is on the menu tomorrow. So it's super great to see you, Drea. It's been a while. Hope you're doing well. And what a perfect timing. Since you bake, they're going to be making lemon pound cake tomorrow. So let me wrap myself up, you guys. I'll share anything I see on the docket for this case, if anything's posted as a community post and over on Twitter. And we'll talk about it tomorrow if there's any new motions as well. Really appreciate you guys and had a lot of fun. So big thank you. I am grateful. And wait, Treykeisha, thank you for being a member for 19 months. She says, I'm the GOAT. You're the GOAT. Thank you so much, you guys. Please have a good one and see you tomorrow.